The zombie drug is sweeping through The zombie drug is sweeping through America right now. Eerie footage coming out of Philadelphia shows crowds of people slouched over but still standing. The insane part is that this is a common scene in almost every major city in America. They look like they are conscious, but not at the same time. The drug they are on
Post 9, Honorable Special Judges, NDPS Act, Medical and Health Officers, District Social Welfare Officers, members of the educational institutions, police officers, lawyers, prosecutors, NGOs, Rangbashnongs, our distinguished guests and resource persons, a very good morning to you all and a hearty welcome from us all to you. We have gathered here with a common purpose to be aware and to be sensitized about the ill effects of substance abuse and to deliberate on the roles of multiple stakeholders on how to effectively address the problem. Article 47 of the Constitution of India mandates that the state shall endeavor to bring about prohibition of consumption except for medicinal purposes of intoxicating drinks and of drugs which are injurious to health. Through this workshop, we aim to shed light on various aspects of the NDPS Acts and equip ourselves with the knowledge and the tools in providing a harmonious living environment for the public at large, particularly the youths in urban and rural areas. Before we move on to the other sessions, I think that the program would be amiss without a speech from the director of the Meghalaya State Judicial Academy. Join me in requesting Ma'am Kerpa Meida Lingdot Nongbri, Director of the Meghalaya State Judicial Academy, to say a few words.
A very good morning to each and every one of you. And a big thank you to each and every one of you also for being here today early in the morning. I know we've started the schedule a bit early, expecting all of you to be here by 8:30, but we appreciate the efforts on your part. Now briefly, the Meghalaya State Judicial Academy, under the guidance and instructions of the Meghalaya High Court, has come forward with this program today, looking at a very important topic, which is the Narcotic Drugs and Psychotropic Substances Act. Now we are very happy that the High Court has requested the Academy to address this subject matter and to involve all stakeholders who have come here today. We understand that this is a subject matter which is very important, a subject matter that has drawn the attention of many, and a subject matter that needs to be addressed from all angles. We are happy that we have here from the Police Department, who has been a strong supporter of the Academy, the Social Welfare Department, the Education Department, and yes, the Rangbashnongs, the other stakeholders, educational institutions with all their representatives, and we also have judicial officers who are playing an important part while delivering matters pertaining to the subject. And I would just like to express here that whenever we mention about this particular subject and that we are holding this workshop today, there has not been any negative response when it comes to saying that this is a very important subject and it is the need of the hour. It is a subject matter that has affected not only an individual, not only the professionals, but it has affected families, societies, and each and every one of us have been affected, either indirectly or directly. And we're happy that we have here with us the Honorable Director General of Police, Shri L.R. Bishnoi, who has been an expert in this field, both in a practical way and also otherwise. Yes, we also have with us another important resource person who has had his own share of experience as a judicial officer, as a former principal secretary, Dr. J.N. Baruwalia, and also an author on this subject. We also have an expert from the police department, a very important department that plays a very, very important role here, Shri Banrab Lang Jirwa. We would like to express our gratitude to him, and we know that he will be able to address issues which have been expressed by most of the headmen and office bearers, that they face many difficulties when such cases of drugs, seizures, or any other matter in their localities, and how do they address it. And we hope that this resource person will be able to address that. And yes, looking at the educational institutions, the counselors, the teachers, where we would not have even imagined in this day and age we will have this problem, where schools will have to address the issue of drugs. Schools will have to address the issue of depression, where many students would turn to drugs as a resort for remedy, for relieving whatever that they are going through. We are happy that we have counselors and educators here with us, and we also have a resource person, Dr. Chayanika Sarma, who will address that issue. And I hope any doubts, anything which needs to be asked, which needs to be clarified, can be done so in this platform today. And yes, at the very last, we will have a very important and special session with the Honorable Chief Justice, Justice Sanjeev Banerjee, who has been the instrumental force behind this program. So without any further ado, I welcome you all once again, and I wish that this program today will be a program which is worth it, which we will leave with an important message, an important task, and also with an even more important sense of responsibility. Thank you.
Thank you, ma'am, for your wonderful and inspiring speech. May I invite Shri L.R. Bishnoi, Director General of Police, to the dais to address the gathering. Before our Director General of Police addresses the gathering, may I request Ma'am Barisukriam, Registrar Judicial Service, High Court of Meghalaya, to kindly present a small token from us. Welcome to the dais.
The office bearers from the Honorable High Court, the Meghalaya State Judicial Academy officials, the officials from the Health Department, Social Welfare Department, and the Meghalaya Police. First of all, let me express my sincere gratitude to Honorable High Court and the Meghalaya State Judicial Academy for inviting me here. Which one? No, it's okay, it's okay, no issue. So for having me invited here and giving me an opportunity to say something on very, very important and relevant topics, that is drug abuse problems in India. I was told that many technical sessions will be followed after inaugural sessions. So some technical experts from the Judicial Department as well as Health Department will delve deeper into the problems. So this topic is a highly relevant topic. Why? Because it's a global problem. The whole world is in the grip of drug abuse problems. I can visualize the only one country which is free from drug abuse is the Vatican City. That is the smallest country in the world. Only 700 to 800 people resides there. And because they are very, very religious people, so they don't do the drugs. Otherwise, not a single country is free from the drug abuse problem in this world today. So in 2019, Ministry of Social Justice and Empowerment, they have conducted a nationwide survey throughout the length and breadth of India. In 2019, they found that at that time, there were 8 crore drug abusers in India. 8 crore. So now this figure may be touching 10 crore. So if the 10 crore youth are the substance abuser or drug abusers in India, you can visualize the gravity of the problems. That is why not only the administrative department, not only the judiciary, not only the health and social welfare officials, all the departments, all the sections of the society are worried about this problem. This is the serious cause of concerns for the nation today. Unfortunately, Meghalaya is a small state, but it is a very, very sensitive state from the drug abuse point of view. Why sensitive? Because it has close proximity to the Golden Triangle area. Golden Triangle, you all know, although it is a golden triangle, but there is nothing golden about it. It's a kind of devil's triangle. So the bordering area of the Myanmar, Laos and Thailand constitute the Golden Triangle, where the opium cultivation is done rampantly. And unfortunately, that area has a poor administrative control and very, very difficult terrains. And the opium cultivation done on a commercial scale there, they have set up their own factories and industries to turn the natural products into the semi-synthetic and synthetic products. And huge numbers, huge quantity of opium is converted into heroin every year, and that heroin is transported throughout the world. So Golden Triangle area is not far away from the Meghalaya. So that is why Meghalaya was and has been the transit route earlier, but in recent years it is not only transit route, but it is converted into the destination point also. That is a one why Meghalaya is a sensitive. Secondly, Meghalaya has a large area with the Bangladesh borders. Nearly 440 kilometers we have border with Bangladesh. So that border remains porous in most of the difficult areas, and because of that, the transshipment of drug consignment is done rampantly. Thirdly, in earlier Meghalaya was known for its drug abusers only in the urban areas. You know, the Mizoram and Meghalaya are the two states, small in size, but if you see the per unit populations, the urban drug abusers are the highest in India. After Mizoram, second is the Meghalaya. As far as the rural drug abusers are concerned, I think Punjab and Goa are the leading states. So that is why Meghalaya is a sensitive. Thirdly, why Meghalaya is sensitive? Because earlier the problem was confined to the urban areas. Now it has started spreading in the countryside, that is a rural areas, and large number of the rural youth are falling prey to the drug abuse. Another problem in Meghalaya, if you see the 10-year or 15-year data, then you can realize that earlier hardly any women was drug abusers. But now the women populations is also falling prey. So male to female, urban to the countryside, these two problems are the new problem which make the Meghalaya highly sensitive states. Although Meghalaya is a matrilineal society, but the rate of broken families per unit population is the highest in India. And those kinds of broken families and uneasy domestic ambience put our children under tremendous strains, and they resort to substance abuse to overcome the stress. So these are the factors which make our Meghalaya state highly sensitive. So you may be surprised why we are here, why we are discussing, why our youth are taking drugs, why they are falling prey to drugs, what are the symptoms and the behavioral changes in the youth, and how we can overcome these problems. So these will be the few of the issues which will be discussed in details. As far as the Meghalaya police is concerned, during last 1 year, we have broken the 50-year record in the seizure of drugs, in the arrest of the drug traffickers, and the recovery of the incriminating materials under Npds Act. In 2022 alone, 116 cases were registered under NDPS Act, but in 2023 till today, we have registered 199 cases. So the problem is continuously increasing, which is worrisome, highly worrisome. In 2022, we have recovered 7.5 kg heroin. But in 2023 till today, we have already recovered 15 kg heroin. So almost our recovery has gone double. And why this is important? You must know what is the seriousness, because heroin is such a potent drug. If any youth takes 3 doses of heroin, 150 milligram, 150 milligram, 150 milligram, only 3 doses if any youth takes, he will become a permanent addict, and then it will be rather impossible and difficult to come out of that vicious cycle. So to make a youth addict, you require only 450 milligram of drugs in 3 doses. That is the dangerous. So if we recovered from January 22 till today, we have recovered almost 22 kg heroin. And 1 kg heroin is good enough to make more than 2,000 people drug addict. In that way, we saved the life of 44,000 youth. So this is the importance of the heroin recovery. Another factor which is really worrying us is the involvement of the interstate drug traffickers. You know, earlier mostly drug peddlers and traffickers, they were locals. But now interstate drug traffickers, they entered into the scenarios. Why? Because it generates huge amount of money. It is a very, very lucrative business. It generates colossal money, you know. So we have arrested, in 2022, we have arrested 234 drug traffickers in 2022, and out of that, 20 were females, and mostly they were highly educated young girls. You will be surprised to know their profiles. In 2023 till today, our arrest figure has gone 304, and out of 304, 40 are females. So you can see the graph. The numbers of the involvement of women in the drug trafficking business is continuously increasing. So that is causing lot of tension in the society. That is one thing. Secondly, out of our 304 arrests this year, we have arrested the drug trafficker from the 18 states of India. You will be surprised that some of the accused were from J&K, some were from Rajasthan, some were from West Bengal, many of them were from Bihar, UP, and all the states, all the 7 sisters of the northeastern states. So you can very well visualize the nexus, interstate nexus prevalent in India. Then our route is highly vulnerable because the drugs produced in the Golden Triangle area, mainly in the Myanmar, because Myanmar has border with Mizoram and the Manipur. So the drugs comes to the Mizorams, and from Mizoram it enters into the Brak Valley of the Assam, and then they take the Meghalaya route, and then it go to Guwahati, and from Guwahati generally it is taken to Siliguri, Calcutta, and then it goes throughout the India. So this is the very, very common route, and you know they have devised a very, very complicated system, so that any driver carrying the drugs from one point to another point, his next source will be totally unknown to the drivers. They always speak in the sign and code language, and to transshipment the drugs from one area to another area, the driver will be given 80,000 rupees per consignment. So you can imagine the greed always overpower the human mind, and that is why once they are in this business, it will be difficult for them to come out of it. because of the money involved. So if any driver, if he takes the consignment of the drugs from the Barak Valley to Shillong, he will get 80,000 rupees. And if from other drivers, he will hand over to consignment to the other driver, and then other driver will take it from Shillong to the Guwahati, he will get another 80,000 rupees. And then from Guwahati to Siliguri, the third driver will get another 80,000 rupees, because the heroin is a very, very costly drugs. And the market rate in the illegal market, the heroin rate ranges from 8 to 10 crore rupees per kg. So you can imagine how costly it is. But in Meghalaya, the available heroin is in the range of 4 to 5 crore rupees per kg. So what is the strategy of the drug traffickers? You know, the first they give the drug free to the youth so that they can become drug addict. They will lure the youth in their trap by giving free drugs to them, and once they become drug addicts, then they have to purchase their own drugs. So they are left to their own, nobody will take care of them, and this will cause tremendous burden on the society, because this is not an isolated crime. Drug abusers will involve in other kinds of crimes also. The first, he will involve in argument with the family members. If the family members will not come to his demands, then he will start quarreling with the family members and beating family members. So this is a kind of domestic violence. This is one thing. Secondly, he will indulge in petty crimes like theft and snatching and stealing mobile phone and all those things. So the one crime lead to another crime. That is the complex web of crime nature involved in it. Drug addict is not the only persons who will commit crimes, but other sections of the society will also be impacted because of it. So what are the impacts? There are different kinds of impacts are there. Results, consequences. The first is the physical impact. If any drug addict is there in the society, he will be totally physically damaged. His central nervous system will be completely altered. He will not be able to understand any logic, reasonings, and he will be burden on the society. So that is a physical impact. Second will be the medical impact, because if the family takes him for the treatment, he has to undergo a long treatment. Doctors will tell you how much the period is involved in it. So that is a medical impact. Third will be economic impact. The drug addict will become totally non-productive as far as the society is concerned. He will be useless for the society. You will not get any productivity out of him. So the economic consequences are very dangerous. If the 10 crore people are drug abuser in India, you can very well visualize the economic loss the nation is suffering because of these problems. Then, of course, the legal problems will be there, because they have to fight the cases in the court to overcome these cases. So this is also a long drawn process. So legal, medical, physical, then there will be a social impact. Because once the drug addicts are there, and if they are in the prime age, so people will be scared to even give their daughters to get married to them, you know. So this is a social problem. So in Haryana and Punjab, the many drug addicts, because nobody wants to marry their daughters with them, so they remain unmarried, and that is becoming a big social problem. It looks very funny, but now the Haryana government has given a special pension to the bachelors, so that they should not create any problem in the societies. And sometimes they resort to dharna to DC office that please someone should arrange our marriages. All those kinds of social problems are there. So you can very well understand the gravity of the people. This is not only a problem in India, but the mightiest of the mightiest nations are also in the grip of this problem. Can you imagine in America, every year, 1 lakh people are losing their lives to the drug abuse problems. 1 lakh. It is not a small figure. In America, superpower, one of the mightiest nation on this planet, but still they are not able to solve the problem. And this problem is a long drawn problem. It's not a simple problem. And in European countries, in England, in Italy, in Netherlands, everywhere the society is in the grip of this problem. So I'm showing a small video. That video belongs to USA. How the American cities are in the grip of drug abuse problem. You can just see it. Can somebody play the video, please? So, how much time it will take?
Zombie drug is sweeping through America right now. Eerie footage coming out of Philadelphia shows crowds of people slouched over but still standing. The insane part is that this is a common scene in almost every major city in America.
Every major city.
They look like they are conscious, but not at the same time. The drug they are on is called xylazine, or more commonly known as trank. It is known to place people into a zombie-like state where they are unable to move and seem to lose all awareness. People using the drug are put into a complete trance and can be seen walking around like an animal. The drug causes infections of the limbs, which most commonly result in amputations. It has been described as being so addictive that even a single accidental hit of it could get you hooked. Trank is now in about 90% of Philadelphia's drug supply and can be commonly found in low-income areas of almost all US cities. You can walk downtown right now and most likely see people like this. Looks like it's time to get out of a...
So this is just to give a glance of what is happening in America, one of the mightiest nations on this earth. And what the video has mentioned, this is a problem in almost every city of America. Video may belong to Philadelphia, so you can very well imagine the gravity of the problems. And the drugs have many nicknames throughout the world. More than 10,000 nicknames are there of the drug. Can you believe it? Some of the common names like white, crystals, ice, glass, boomers, yellow sunshines, crystals. All these are the nickname of drugs. And in Meghalaya, the nickname which is very common is I love you. That is the name of the drugs. If some youth is ringing and if he is saying that I love you, don't be under impression that he is expressing love and affection towards you. So he is dealing about the drugs. So that is the name. Recently we have cracked the code in Meghalaya and came to know that this is also the name of the drugs. So always they talk in the sign language and the code languages. As the saying goes, intellect is always not the wisdom. There is a difference between the intellect and the wisdom. Our ancestors, who were very wise, full of wisdom, they may not be literate like young generation today, but they were full of wisdom. So nowadays, throughout the world, many intellectuals, many scientists, many celebrities, many prominent personalities of the world, they are also taking the drugs. And historically, many prominent persons have taken the drugs. Some names are there with me: Marilyn Monroe, Elizabeth Taylor, Elton John, Carrie Fisher, Matthew Perry, Matt Damon, Angela Jolie, John F. Kennedy, the president, the Mao Zedong of China, Winston Churchill, the Prime Minister of England, Thomas Jefferson, the then President of USA, George Washington, Adolf Hitler, and the B. Franklin. All those people were taking drugs, although they were highly intellectuals, but they were taking drugs. And in Bollywood, you will see that many prominent actors and actresses, they are also taking drugs. So there is a difference between the intellect and the so this is another video you can see. So irresponsible behavior. Let's see the young girls under influence.
ओके ठीक है अच्छे से मैं आप लोग बात करते हैं क्या कुछ दिमाग में होता है क्या काम होता है
She kicked the lady.
ಓಪನ್ ಮಾಡಿ
ಕೈ ಕಾಲಿಗೆ ತಪ್ಪಿ ಗಾಡಿಗೆ ಹಾಕಿನಿ ಕರ್ಕೊಂಡು ಹೋಗಿ ಗಾಡಿಯಲ್ಲಿ ಹಾಕಿ ಚೆಕ್ ಮಾಡಿ
ಗಾಡಿ ಸಿಗಲ್ಲ ಗಾಡಿ ಹೊಡಿತಾನೆ ಓಪನ್ ಮಾಡಿ ಗಾಡಿಲೇ ಸಾಯಿಸ್ತಾಳಂತ ಇವರು
ಗಾಡಿಗೆ ಹಾಕಿ ಬಿಡಬಾರ್ದು ಮತ್ತೆ ಹಾಗೆ ಬಿಡಬಾರ್ದು ಈ ಕಡೆ
ಹಿಡ್ಕೊಂಡು ಕೆಳಗಡೆ ಹಾಕಿರ ಉಳಿತ ಮಾಡಿದ
ಇದೆ ಇದೆ ಅಲ್ವಾ ಮಾಡಿ ಅಲ್ಲ ಕಾಲಿಗೆ
So these two small videos I have shown that when any youth takes drugs completely alters the central nervous system, whether it is a depressant, whether it is stimulant, or whether it is hallucinogens. Completely his function is altered, and he is not aware, he or she, they are not aware what they are doing. See the young girls, how the irresponsible and violent behavior is there. And this is the daily problem our policemen are facing in the Thana as and when the drug addicts are arrested. So this is the kind of the behavior we face. But it's very, very difficult to control them because their behavior is not under their controls. Drug is controlling their behaviors. So why our youth are falling prey to the drugs? We have analyzed certain reasons after interactions with the drug addicts and after interactions with their family members. The first reasons I found here is the domestic discord, domestic fissures or distrust in the family. Second is the young ones are also imitating friends. And third will be the peer group pressures from their friend circle. Then curiosity, just to test what is the drugs. And then you know the risk-taking behavior of today's youth, and just to overcome the stress, anxiety, and boredom, they also resort to the drugs. So these are the few of the reasons we have analyzed after our interaction, why such educated youths are taking drugs. Particularly in the educational institutions and the schools, etc., unfortunately, students, they take the drugs to overcome, even to remain awake during the examinations time. Particularly, you might have heard about the ecstasies or MDMA drugs, methyl dioxymethamphetamine or methamphetamine tablets they also take sometimes, so that they can remain awake. If one tablet is taken by any students, he can remain awake for 3 to 4 continuously, sleepless night, he can pass no problem, but his brain will be damaged. So that is the students also, the problem is increasing in the educational institutions. Then we have also observed the certain signs and the behaviors. We have noticed that as and when drug addicts are taken into the police stations, we observed certain the physical signs like glazed eyes or dull eyes, and the nose runnings or the coughings or the weight loss, or the loss of wearing sense of appearance, all those kinds of the physical symptoms are there. Then with the expert of the qualified counselor, we have also observed some of the behavioral changes or mental behavior, like irresponsible behavior you have seen in the videos, then involvement in lot of argumentative behavior, then solitary behavior, they always avoid the company of their friends and generally wanted to remain in the solitary ambience. And then drastic decline in the educational performance or the falling grade levels or the score in the schools and colleges, that was another symptoms we have noted. But unfortunately, highly educated sections of the societies are also in the grip of these problems. So 2019 survey, as per that survey, in 2019, 2.5 lakh drug abusers were there in the state of Meghalaya. 2.5 lakh. So this figure may be touching more than 3 lakhs. So what we can do? All the stakeholders of the societies are here. The problem is so complex, challenges are so complex that it should not be left alone on the shoulders of the police department. Every section of the society has to come forward. Let us fight this problem unitedly and jointly. We want cooperation from all the sections of the society, particularly Rongbashnong, Darbashnong, the community leaders are sitting here. So they have to assist us to overcome this problem. As far as Meghalaya is concerned, we have adopted 6-pronged strategy to overcome this problem. The first is the creating awareness in the society, that is a preventive aspect of the drug abuse problems. And you will be happy to know that from 12th June to 26th June, because 26th June every year it is celebrated as an International Day Against Illicit Drug Trafficking. So from 12th June to 26th June, during a period of fortnight, 15 days, the Meghalaya police has organized 1,289 awareness programs in the school, colleges and university, and that is the national record. We have created national record. In no other states in India so many programs were organized, awareness programs in the society, and we have covered nearly 8 lakh students and created awareness so that they can remain conscious and vigilant about the gravity of this problem. So this is our first strategy, and our awareness program will continue, and we seek cooperation and help from all sections of the society. The second strategy we are adopting is the sustained crackdown against the drug trafficker, that is the enforcement part. And you know that during last 1.5 years, we have arrested nearly 400 drug traffickers. We have recovered 300 mobile phones. All the mobile phones were put under surveillance, and with the help of those numbers, we were able to break their forward and backward linkages. That is why arrest is so much, and recovery and arrest have broken the earlier 50-year records of the Meghalaya police, and this sustained crackdown will continue unabated throughout the length and breadth of the state. This will be our second strategy. Our third strategy will be that imparting training to our own police officials so that they can submit the robust charge sheet in the court, and it can lead to the prompt conviction, because our conviction rate is very low, frankly speaking. It has not touched even the double digits, and that is cause of the concerns, and many accused were released on the bail because of the poor investigation or procedural lapses in the investigation. We have analyzed 110 cases recently, and we found that 80% cases are failing in the court because of the procedural lapses. So that is why we have started imparting training. The training, 5 number of training modules are prepared, covering all the officers of the police so that they can go for the robust investigations and conviction can take place. This will be our third strategy, and it will continue. Fourthly, we are using the technology. Using the technology means that we have obtained the drug detection kit for all the 80 police stations of Meghalaya. Then we are also going to use the Nidan portals and also the N-code portal started by Narcotics Control Bureau. And we are also using the NAFIS, that is a National Automated Fingerprint Identification System. We are recording the biometrics of all the arrested accused so that it can remain permanent electronic records. So use of technology is in a massive way. We are also using the social media. We have created our own social media platforms, the Facebook, Twitter, and Instagrams. And you can say the Facebook page of the Meghalaya Police is also active. And all the police stations and the districts, they have opened their own Facebook and Twitter accounts. So that is another strategy. And then our last strategy is the involvement of media, because media role is very, very important to create colossal awareness in the society so that people can understand the gravity of the problem. So these are our 6-pronged strategy to overcome the drug menace in the state of Meghalaya. I hope that our strategy will give some good results in the coming days, and we want to see the youth of Meghalaya happy and smiling. We don't want that our young generation should be ruined by the drugs. So that is why my sincere appeal to all the stakeholders of the society that please come forward and let us fight this menace jointly and unitedly. And my appeal to all the parents and all the community leaders that please try to create awareness in the society that so that the problem should not remain hidden. The people should not feel hesitate that our wards are in the drugs. They should not feel hesitation, otherwise the problems will become more complex with the time. If the timely disclosure and taking the help of the medical doctors and the qualified counselors will lead to the solution of the problems. This problem is a very, very serious problem, and we require more number of drug de-addiction centers. As per the Inter-Ministry Committee, that IMC, the resolution was adopted that all the 700 districts of India should have at least drug de-addiction center. So in Meghalaya, there are 12 districts, but 12 drug de-addiction centers are not there. So we want that every district has at least one drug de-addiction center so that our youth should not required to go to outside Meghalaya for their treatment, because it is costly also and it creates other economic problems. So these kinds of the issues are discussed at the highest level, and the government is also concerned, and we are also committed that this problem should eradicate permanently. And we can feel happy only if the problem is eradicated permanently, and the society can be very peaceful, very healthy and happy and peace-loving. Because intermittent seizures are not the solution. And these seizures, let me accept, these seizures are only the tip of the iceberg. Out of total circulation of drugs in India, the seizure by the various enforcement agencies may not be more than 5%. It means 95% of the drugs are circulated in India without seized by the enforcement agency. All kinds of enforcement agency if you combine. Mean if we have seized 22 kg heroin during last 1.5 years, so it is a 5%. Then 95% already cleared, already gone to the society, to the drug abuser. And for your kind information, every year in the world, 560 tons of heroin are produced. Can you imagine? To make a person drug addict, you require less than half gram of heroin, and in globally 560 tons of heroin are produced. So this problem, I can visualize the gravity of the problem in coming days, how this problems will be there and how serious it will be there. This is the issue where a number of the resolutions were adopted in the United Nations General Assembly. United Nations international conventions are there. Every country has promulgated their own rules and acts, but still problems is remain. And let me tell you the drug is the only issue in the world which has led to the two wars. They are known as Opium War. First was in 1839 to 1842, fought between China and England, where the China was defeated. And the second Opium War, this is known as Opium War because the war was fought between the two nations on the supply of the opium. The second was between 1856 to 1860 because the Chinese dynasty or Chinese government wanted to dismantle the drug supply, and the England was opposing it because England was getting a lot of economic benefit out of it. So that this is a general knowledge question. Drug, it has led to the two war known as Opium War. You may be aware, history students, if you are sitting here, definitely you might have heard. So I don't know, in the future also, there may be war on drugs. The way the Colombian warlord or Mexican warlords are creating problem in the USA and for other countries of the European countries, this may lead to the international war also, you never know. But let us not go for global problem, let us stick to the problems faced by the youth in our states. So my appeal only is, please don't hesitate to share informations about the drug traffickers in your respective area. If all the 40 lakh people of the Meghalaya come forward and start sharing the information, then I have no doubt in my mind that we can solve these problems unitedly, jointly, very soon. So with these words, without prolonging my speech further, once again, my special thanks to the Honorable High Court and Judicial Academy and all the other stakeholders like Law Department, Social Welfare Department and our own Meghalaya Police for organizing this beautiful program. I'm dead sure that after day-long discussions and if you hear the opinions of the experts, you will go very enriched from this conference. And this knowledge will help to overcome this problem. My best wishes to all the resource persons and to all those who are present here to attend today's conference. Thank you very much.
Thank you, sir. Your dedication towards the service is an inspiration to us all. Now, we move on to the technical sessions of this workshop. To start the technical sessions, let us gain a deeper understanding of the NDPS Act. Oh, yes. We will first have the tea break. So, after a long speech, tea break will give us a break. So let us move on for the tea break. Awake. So now we have our resource person, Dr. J.N. Baruwalia. An introduction has been given by Ma'am Director earlier. So now, without much further ado, I would like to request Mr. J.N. Baruwalia to the dais for his deliberations. And before his address, I would like to request Ma'am Barisukriam, Registrar Judicial Service, High Court of Meghalaya, to present a token from us. Thank you, ma'am.
Very good morning, friends. Respected Karap Meda Langdo Nong Bari, Director of the Academy, and all my friends who have assembled here today. Friends, I am grateful to the Honorable Chief Justice of the High Court of Meghalaya and the Director of the Academy to afford me this opportunity this morning to have interaction with you on a very, very important subject, as Mr. Bishnoi has told you, that is investigation, prosecution and trial of NDPS Act cases with special reference to important judgments. Today, we have here the judicial officers of State of Meghalaya, the investigating officers, the officers of the Law Department, the Social Welfare Department, the Education Department, the headmen and members of Dorwar, SNONGs, NGOs, Meghalaya AIDS Control Society members, counselors and members of educational institutes, and other stakeholders. I congratulate the High Court of Meghalaya, Social Welfare Department, Law Department, and the Director of the Academy, because this conference will go a long way to sensitize all those involved who are the stakeholders in the eradication of this big problem in India, not only India, but international problem of drug addiction. Friends, I know this is not the age to teach and to be taught, but we learn every day. I have learned a lot from the views expressed by Mr. L.R. Bishnoi, the Director General of Police here. Friends, in 1984 to 86, I was posted as Chief Judicial Magistrate in Kullu, Manali district, and there the problem of hippie cult was. It was there in 1984, 85, 86, hippie cult was there, and many foreigners and Indians were addicted to church, ganja, heroin. And what we have seen regarding America in the video today displayed by Mr. Bishnoi, that condition was prevalent in Manali area. I remember Mr. Justice Sabyasachi Mukherjee, who was number 2 judge in the Supreme Court of India in 1986, came to Kullu Manali, and I was attending upon his lordship during the entire visit to Kullu Manali, Rohtang, etc. And for 4 days I remained with him, and we discussed this problem of drug addiction and hippie cult prevalent there. And I am grateful to Justice Sabyasachi Mukherjee that he suggested me that you write, because you have the experience on this subject so much, that you write a book on narcotic drugs and psychotropic substances. And as a consequence, I tried my best to present the commentary on the narcotic drugs and psychotropic substances, which was published in 1992. But it was my ill luck that Justice Sabyasachi Mukherjee died in England when he was Chief Justice of India. And then the foreword to the book which he was to write was written by Justice R.S. Pathak, who was at that time Judge International Court of Justice after being the Chief Justice of India. So friends, Mr. Bishnoi has rightly pointed out that this problem of heroin is very dangerous. If a person is addicted to heroin, then it is very difficult to bring him back to the society. Because it will take, our doctor will agree with me, it will take 3 months for de-addiction. And Mr. Bishnoi has rightly pointed out that this problem of drug addiction have effect physical, medical, economic, as well as social impact. I know he has given an example of Punjab and Haryana that there nobody is giving girls to a drug addict, and it is a fact. It is a fact. But we have to see the other aspect also. In Punjab, Haryana, it was prevalent earlier that the mothers, that the lady used to administer small quantity of opium to the infants so that they sleep and the ladies can go and work in the fields and do other household work. This was a social, this was in the society. But today, this opium and heroin are the enemies of our coming generation. The flowers of today, the generation of tomorrow, that is the school children. Friends, in Shimla, the doctors of the Indian Indira Gandhi Medical College conducted a survey about 5 years back. And what they found, 17% of the students studying in schools in 9th and 10th classes, as well as college students, both convent and government, were addicted to drugs. 17% is a very big number. In Manali, we had a conference of the judges and police officers of northern states, which consists of Punjab, Haryana, Himachal, Delhi, and Rajasthan. Even High Court judges were present in that conference, and the Chief Justice of India, Justice T.S. Thakur, presided over that conference. For 2 days, the deliberations were there, and the third day was kept as open house. And on third day, when it was open house, it was asked by Honorable Chief Justice of India, anybody who wants to point out any problem may come up and discuss the problem. The daughter of Secretary Law of Delhi, who accompanied his father to Manali, had gone the previous day to Manikarn. It is a place in Kullu. And she narrated the incident that yesterday I went to Kasol. There is a place, Kasol, it is famous. Many foreigners are residing there. They are the drug lords in that area. It is being international. It has become the international problem because Manali Church, Malana Church, that is the best church in the world. And the price in Kullu, Manali, I will come to that later on. She narrated that yesterday I went to Kasol and I sat in a restaurant. I asked that give me a cup of coffee. I was with my friend. The restaurant waiter who attended upon her told that there is no coffee and tea available. You tell you want church, opium, heroin, or any other drug. The result was the Inspector General of Police was present there, SP of that district was also present. They asked from them, what is this? And next day, the SP was transferred, and many hotels have closed in that area due to this problem, and a number of drug addicts and the suppliers have been arrested. So this is a great problem, friends, and this picture you are seeing in this video is poppy cultivation in poppy cultivation in Rajasthan, and these flowers are ready for extraction of opium. This is illicit, not illicit, licit. For medicinal purposes, the permits are given there to grow this, and the entire opium is given back to the government. So drugs. Every day we hear in television and read in papers that a huge quantity of narcotic drugs has been recovered from one or the other part of India. Even yesterday, Mr. Bindoi was discussing that truck drivers are given 70 to 80,000 per visit to take drugs from one place to another place. But in our area, Punjab, Haryana, and Rajasthan, a new system has developed. Drones. The drugs are being sent through drones. And daily we read the newspapers. Yesterday also there was a news item that 3.5 kg of heroin has been recovered, which was thrown by drone in Firozpur area of Punjab. So this is what is happening. And the dangers flowing from illicit traffic in narcotic drugs have been recognized worldwide and so agitated the conscience of world community that they are the subject of international conventions like Single Convention on Narcotic Drugs 1961, the Convention on Psychotropic Substances 1971, and the Convention on Illicit Traffic in Narcotic Drugs and Psychotropic Substances 1988, to which India is a party. So friends, this 1961 Single Convention, so agitative was the world community that it recommended, this conference recommended that the state parties should bear in mind that drug addiction is often the result of an unwholesome social atmosphere in which those who are most exposed to the danger of drug abuse live. Secondly, the state parties should do everything in their power to combat the spread of illicit use of drugs. And third, the state parties should develop leisure and other activities conducive to sound physical and psychological health of young people. That is very important. Our children, the flower of today, the future of tomorrow. Friends, the latest initiative to focus international attention on the global drug problem was taken by UN General Assembly in 1988, and in this, to control the drug menace, the United Nations has set up 3 bodies to carry out United Nations objective. First is the Commission on Narcotic Drugs. It helps on all drug-related matters to the Economic and Social Council of the UNO, the policy-making body of the UNO, and second is International Narcotic Control Bureau Board to monitor the implementation of all 3 drug conventions 71, 61, 71, 88 with monitoring and screening of the production, trade and use of licit and illicit drug, and to work closely with national governments. Then third is the UN Office on Drug and Crime, and the main stress is on reduction of demand. That is the main stress of all these conferences. So friends, drug abuse, drug trafficking, armed trafficking, money laundering, and narco-terrorism, all these are interconnected, and they are all white-collar crimes faced by the new millennium. The causes for drug abuse. Friends, Mr. Bishnoi has beautifully explained broken families, then hippie cult, peer cult, then to have new experience. All these are the causes, but they are, and along with that, the activities of smugglers who want to create demand so that they can sell their product in the market at a higher rate. Supply and demand. But friends, in my book, which was published in 1992, I said no. There are other reasons also, causes also, and the first cause is drug war. What is drug war? Narco-terrorism may be defined as a threat to humanity by waging a drug war, and drug war is a war being fought by our enemy country on our land, with our men, with our material. Everything is ours. What they were doing earlier, they were taking our youth to their country, making them drug addicts, then giving them guns and sending them back to India. and then they were supplying drugs to them to make other people also drug addicts, as well as to do terrorist activities. So this was one. Second, as we know, the organized gangs of smugglers, that is always there. They are internationally operating. By smuggling, friends, because the margin of profit is too much. By smuggling a bag of heroin, the kingman who is sitting in his house will earn $500,000. He is not doing anything. And I know in Kullu Manali, all these foreigners who have come from mainly, they are from Canada, they are from other Italy and other countries, and their modus operandi is they purchase the vehicles in the name of the drivers. Drivers are the owners, and if the consignment is caught, he will be arrested because he is the owner of the vehicle, he is carrying the drugs. So this is the modus operandi, and we know many governments have been overthrown by the gangs of smugglers, and we hear regarding Cambodia almost every 3-4 years that the government is thrown by the drug lords. Here, friends, I will give one particular example. This Mr. Sanji Mohan, very important person. He was the director of the Narcotic Control Bureau at Chandigarh. He was in charge of 5 states of Punjab, Haryana, Himachal, J&K, and Delhi. He was in charge of 5 states. As you all know, this NCB, Narcotic Control Bureau, is the body which is controlling, which is coordinating all other agencies for the prevention of drug addiction in their country. And this man had delivered lectures with me at many places in Punjab, Haryana, Himachal, and other states, because he was the director of the NCB, Narcotic Control Bureau. But we all were surprised one day when we read in the newspaper that this person has been arrested in Bombay with a huge quantity of heroin. So he has taken heroin from the Malkhana to Bombay. So even a person of such a high post, he was involved in this racket, only because the margin of profit is too much. He would have earned crores of rupees in one consignment only. So third is what I propounded. The third is activities of chemists and druggists. The young addicts start with cough syrup like Finsadrel, Corex, then move on to Proximon, Dormanten, Diazepam tablets, Idex on bread, etc. And going on, he moves to more lethal means, menu of ganja, churs, opium, mandrax, smack, and heroin. In our area, it is known as chitta also. The abuse of cough syrups, painkillers, and sleeping pills has risen considerably during the past few years. And friends, I may tell you, in Punjab, Haryana, even we hear of that open bazaar is held of these medicines on the pavements also sometimes. So this is a problem, because there are certain persons who wants to earn, chemists and druggists who wants to earn money, otherwise they can't sell it without prescription. duplicate prescription has to be taken and then they can sell it, but they are selling it without prescription, and this way our youth is becoming drug addicts. Then culture change, leisure tourism is always there, jail culture is there, other personal and family reasons, as Mr. Bishnoi has told you. We must remember that drug addiction and drug abuse is not a law and order problem and is more of a social problem. So all these NGOs and the headmen and members who have assembled here, they can help us to eradicate it from the social angle, from the society. They can play a very... Friends, the drug addict does not simply use drugs but develops a pathological craving for drugs, and the desire is so strong that the addict must have his drug at all costs, whether in cash or in kind. The dimensions of drugs and drug trafficking are so high that these have not only claimed millions of lives but have endangered the society as a whole by weakening the national economies and shaking even the stability of some other governments like Cambodia. As Mr. Bishnoi has told you, there were almost 10 crore drug users in India, but now the figure is, what latest figure I have, there are about 7.3 crore drug addicts, not users but addicts in India, and in Meghalaya, friends, the number of drug abusers, including injectable drugs and psychotropic substances, are 2.5 lakhs, as Mr. Bishnoi has given the figure. In India, the number of children between the age group 11 to 18 years is 1.2 crores. It's a very big number. And the number of women is approximately 55 lakhs. The symptoms, friends, I will not discuss because we have problem of time, but 8 to 12 hours he becomes, if there no drugs is not given to him, you have seen the picture, nervous, restless, 12 to 24 hours, sweats profusely, running of eyes and nose is there, 24 to 36 hours, severe twitching of muscles occur within 36 hours, then cramps in the legs and abdomen, and finally all fluids are released after 72 hours, vomiting and diarrhea is there, and finally the addict shall go to the grave of his own making unless he is given expert medical treatment for de-addiction and detoxification to make him a good member of the society. So friends, the Indian Parliament recognized the need of the hour, Golden Triangle and Golden Crescent, two areas adjoining us, enacted the Narcotic Drugs and Psychotropic Substances Act 1985, in which deterrent punishment of rigorous imprisonment which shall not be less than 10 years and fine which shall not be less than 1 lakh rupees was prescribed for those found guilty by most of the offences under the Act. And then in 1989, by Amendment Act of 2 of 1989, even the breathtaking punishment of death penalty has been provided for specified offences by previous convicts under Section 31A of the Act, as you all know it. Then, friends, I was also associated with Law Commission of India to make suggestions for the amendment of this Act, and the amendment came by Act number 9 of 2001. The contravention of narcotic drugs has been categorized for the purpose of punishment into small quantity, then intermediate quantity and commercial quantity. And while the Act has provided stringent and severe punishment for drug addicts, drug traffickers, and for possession of commercial quantity of narcotic drugs and psychotropic substances, it emphasizes a reformative approach towards addicts of such drugs and substances. I will discuss it just now. Friends, under Section 36 of the Act, the offences punishable with imprisonment for a term more than 3 years are triable by special courts constituted under the Act. And what about less than 3 years? all offences punishable with imprisonment for a term of not more than 3 years under the NDPS Act are triable by judicial magistrate who may try the case as summarily. So this is the provision for trial of the cases. Friends, the judges have to decide the cases. Judges have to decide the cases on the basis of first facts, evidence, second is evidence, and then law. Facts, friends, all police officers are here. Friends, I must say one thing, that we must appreciate our police officers. They are doing excellent work in India. Any act which is passed by the legislature, even NDPS Act, what is the provision? NCB is the agency, main agency. And then 13 central government agencies are there, DRI and all others. Then state government, even excise officers, other officers, they are there, who are invested with the power of police officer to do the investigation. But it is only the police officers who are doing the work under the NDPS Act also, and all other agencies, we are seeing very few cases. Even NCB, we are seeing very few cases. The implementation has been left only to the police, which is already overburdened. So what is the use of these 13 agencies if everything is to be done by the police only? The facts are in the investigation by the police or investigating agency. Then evidence is produced by the prosecution, and the prosecutors also there in this workshop. Then law, as declared by the courts and as per the NDPS Act. So this is what the judges have to keep in mind while deciding the case. And friends, under Article 141 of the Constitution of India, every judgment given by the Supreme Court of India is binding on each and every court in India. So, any judgment passed by the Supreme Court of India binds us. And therefore, now coming to the investigation, friends, investigation is not an end in itself, but means to find out the truth. When more stringent punishment has been provided in the NDPS Act, correspondingly more safeguards have been provided for conducting fair investigation of the cases under the Act. Chapter 5 of the Act lays down the procedure for conducting search and seizure under this Act. Our friends, as Mr. Bishnoi has also told you, and I am also explaining it, our experience has shown that a large number of cases instituted in courts in respect of various offences under the NDPS Act have ended in acquittal not on merits but on technical grounds of non-compliance of one or the other mandatory provision under this Act. So this is technical acquittal. I heard Mr. Bishnoi who told that even conviction rate is not double figure here. But friends, I may tell you, in India, overall conviction rate in narcotic cases after this amendment of 2001 has increased from 17% and now it is between 39 to 43% overall conviction. And it is also due to the various conferences being organized by the National Police Academy, National Judicial Academy, State Judicial Academies in coordination with the police departments of various states. And I had been to most of these conferences. I am going to National Police Academy since 1993 for the last more than 30 years. I am visiting that academy. Every time I go there, I learn too much from there from my experience. So next, friends, what is investigation? Investigation means to search into, first to search, second to examine closely, and then to explore the possibilities. That is very important for investigation. The aim of investigation is to bring out the truth, to locate the persons who committed crime, to collect evidence, physical, oral, circumstantial against them, to arrest such persons, and to bring them to courts. So friends, the investigation role is over the day you prepare the case. And in Jabna versus State, AIR 1974, Supreme Court 181822, the Supreme Court has held that purpose of investigation is to bring out unvarnished, very important, unvarnished truth. No padding, unvarnished truth. And for physical evidence, friends, because our forensic science has developed a lot, DNA is there. So there is so much today in forensic science, and for this purpose, I will only request my investigating officers that they should be very particular when they visit the spot. How to enter the spot? What happens? Suppose the narcotic drug is lying here. It is lying here. Narcotic drug is lying here. And I get a information that there it is lying. What generally our investigating officers are doing, they jump on the spot. They will go running and they will catch it, hold of it, and then they will come back, okay. Friends, this is not the way. The way is that we should make 3 circles. Outer circle, middle circle, then third, close circle. We should start from the outer circle. The piercing eye of the IO, the piercing eyes of the IO must see each and everything lying on the spot. In every circle, when I am crossing, I must see both the sides if I can find any hair, any footprint, any handprint, any cloth, any blood stain. These are so many things, and all these can be compared through DNA today. And we know in foreign countries what has happened. The persons who were convicted for the last, since 20 years ago, they have been found innocent today due to this DNA science. So these are the things which you have to keep in mind while doing the investigation. This is my suggestion, humble request, humble suggestion to all the IOs present here. Then friends, as I have said, acquittal is not only on merit, but it is technical acquittals. Section 42 of the NDPS Act is very important. It says, if the officer has prior information, has reason to believe from personal knowledge or information given by any person and taken down in writing that any narcotic drugs is in any building, etc., he can enter into and search any such building, conveyance or place. In case of resistance, break open any door and remove any obstacle to such entry, seize such drug or substance, and detain and search, and if he thinks proper, arrest any person whom he has reason to believe to have committed any offense punishable under the Act. So friends, what proviso says that provided that if such officer has reason to believe that a search warrant and authorization can't be obtained without affording opportunity for the concealment of the evidence or facility for escape of an offender, he may enter and search such building, conveyance or enclosed place at any time between sunset and sunrise after recording the grounds of belief and compliance. As far as the compliance is concerned, compliance of Section 42, it has been held by Supreme Court of India in Karnail Singh versus State of Rajasthan. It is 2000 judgment. It has been held for application of Section 42 of the Npds Act. It is necessary that the officer has reason to believe from personal knowledge or information received regarding the movement of narcotic drug or psychotropic substances. However, if the action is taken not upon his personal knowledge or information received, the requirement of Section 42 of the Act would not be applicable. For example, suppose you are doing the investigation. It is a chance recovery. You are doing the investigation in a theft case, and all of a sudden you come across narcotic drugs, then this Section 42 is not applicable at all. But if you have reason to believe or you have information received from any person, then it has to be recorded, and within 72 hours copy has to be sent to the immediate superior officer. That is the requirement. And Supreme Court has held in state of Punjab versus Balbir Singh that if there is total non-compliance of this provision of Section 42, the same affects the prosecution case. To that extent, it is mandatory. But if there is delay, whether it was undue or whether the same has been explained or not, will be a question of fact in each case. So delay, if there is delay, 72 hours, or you have written the report after you have already recovered the narcotic drug, then it is a question which is to be seen as a question of fact in each case. In Karnail Singh versus State of Haryana, 2009 judgment, friends, it has been held that while total non-compliance or requirement of subsection 1 and 2 of Section 42 of the Npds Act is impermissible, delayed compliance with satisfactory explanation about the delay will be acceptable compliance of Section 42 of the Act. And they have given an example in the judgment itself. उन्होंने जजमेंट में ही एग्जाम्पल दिया है, एंड जजमेंट क्या एक्सप्लेन किया है, टू illustrate if any delay may result in the accused escaping or goods or evidence being destroyed or moved, not recording in writing the information received before initiating action, or not sending a copy of such information to the officer superior forthwith, may not be treated as violation of Section 42 of the Act. However, where the police officer does not record the information at all and does not inform the officer superior at all, then it will be a clear violation of Section 42 of the Act. Whether there is adequate or substantial compliance with Section 42 of the Act or not is a question of fact to be decided in each case by our judicial officers. Here the discretion of the judicial officer is there. He has to see whether it has been explained properly, delay has been explained properly or not. If it is properly explained, then accused will be convicted. If it is not explained, then benefit of doubt will go to the accused. So friends, then Constitution Bench of the Supreme Court of India in Sukhdev Singh case has held that in view of technological advancement, it may not be possible to record information as per the requirement of Section 42. Strict compliance by the investigating agency should not be required in any emergency situation so as to avoid misuse by wrongdoer, offenders, drug peddlers. Whether there is adequate substantial compliance is a question of fact in each case. Apart from finding that present case is governed by Section 43, I will come to that next. So this is Sukhdev Singh versus State of Haryana, 2013 judgment. And friends, after this judgment, the conviction rate has increased. Conviction rate has gone up in India because this judgment says it is not a mandatory provision, Section 42. Total non-compliance is fatal to the case of prosecution, but where delay is there, then it has to be explained by the prosecution. If it is explained that it is not fatal to the case of the prosecution, conviction can be there. Then friends, next very important question is, where the search is conducted by a gazetted officer, then this requirement of 42 are gone. They are not to be complied with at all, because the Supreme Court of India has held, and that is binding on each and every court in India today under Article 141 of the Constitution of India. It says M. Prabhu Dayal versus Assistant Director, 2003 judgment, AIR 2003 SC 4311, where a search is conducted by a gazetted officer himself, acting under Section 41 of the NDPS Act, it was not necessary to comply with the requirement of Section 42 of the Act. For this reason also, in the facts of the case, it was not necessary to comply with the requirement of the proviso to Section 42 of the NDPS Act, and the accused was convicted by the Supreme Court of India in this case, although there was non-compliance of Section 42. So this is a very important judgment, and after this judgment also, the conviction rate has increased in India. Then friends, its next judgment I will give, this State of Haryana versus Jarnail Singh, 2004, AIR 2004, SC 2491. It says, the gazetted rank officers enjoy a special position and privileges. Under the NDPS Act, they need not be equated to officers taking action without authorization or warrants. The requirement of sending information to superior officers under subsection 2 of Section 42 of the Act can't be insisted upon in their case. There is no bar in the statute to functions of arrest, search and seizure being carried out by the officers of gazetted rank themselves. When they act on their own, they do not have to report to their seniors on such things. So this is very important, and the role of prosecutors is also very important here, because all these judgments, they will support them while arguing the cases in court, and they can get more and more convictions in this case if they explain all these points in the court. So friends, I will only add one small thing. When I joined in service, long back in 1975, I am topper of 75 batch of the Judicial Service. So at that time, I have seen, in our area it was known as Pairvi. The investigating officer are present in court with the prosecutor on each and every date of evidence, recording of evidence. When the case was fixed for evidence, then investigating officer is present. He is supporting the prosecutor in the court itself, and he is saying that his evidence is recorded correctly in the court also. The witness is speaking the truth in court also. But later on, when I was serving as district and session judge, then I was Registrar General of the High Court, we have seen that even for the examination of the IO, we have to issue summons so many times from the courts. That is the change. Last time I remember, my lecture was here on POSCO in this academy. My lecture was on NDPS also in this academy, and Madam Dhakar, who is sitting here, was the director of the academy at that time. Even I think on this Domestic Violence Act, I have delivered a lecture here. So friends, next is very important. Again, here also the conviction rate has increased manifold. Effect of complainant, informant, and the investigating officer being the same person. In Mohanlal versus State of Punjab, friends, it is AIR 2018 Supreme Court. 2018 this judgment came. It was held as the complainant and investigating officer is the same person. The appeal succeeds. Supreme Court held, appeal succeeds and is allowed. The prosecution is held to be vitiated because of the infraction of the constitutional guarantee of a fair investigation the appellant is directed to be set at liberty forthwith unless wanted in any other case. So what happened, friends? After this judgment, within next 15 days, many accused were released on bail by the high courts who had been convicted by the special judges because of change in the law. Earlier, it was to be seen whether any prejudice was caused to the accused. For this reason, that investigating officer and the prosecutor is investigating officer and informant is the same person. So, in Delhi Judicial Academy on 14 September 2018, I was delivering lecture and this question was put to me, okay, what will be the effect of this judgment? I said it will be operative only from prospectively, not retrospectively. From 2018, the investigations are carried out. This will be applicable. It will not be applicable. As far as academician is concerned, this opinion is mine. I can't say what the Supreme Court will hold later on. But friends, what happened? Very next judgment, next year, 2019, immediately thereafter, in Virender Kumar versus State of Himachal Pradesh, my view was upheld by the Supreme Court of India. They held a proper administration of criminal justice delivery system requires balancing the rights of accused and prosecution so that the law laid down in Mohanlal is not allowed to become a springboard for acquittal in prosecutions prior to the same, irrespective of all other considerations. Therefore, we hold that all pending criminal prosecutions, trials and appeals prior to the law laid down in Mohanlal case shall continue to be governed by the individual facts of the case. The present appeals lack merit and therefore dismissed. So they said no, this Mohanlal is not applicable because these are the cases in which investigation was carried out before 2018 when this judgment was not there, Mohanlal case. So here it is not applicable at all. And the appeals were dismissed on this ground and this judgment is later judgment and then, friend, the matter was referred to larger bench because there were two judgments. One said Mohanlal, straightaway acquittal. The other said no. It will be applicable only after this date. And then 3 judges bench was constituted in Virender Kumar versus State of Punjab, and in 2020 this judgment came, AIR 2020 Supreme Court, and what was held? They held it has been held that as in the subsequent, again in the judgment delivered on there, shall continue to be governed, the case pertains to, yes, it held prior to the judgment in Mohanlal case, the judgment in Mohanlal case shall not be applicable, and in this Virender Kumar versus State, they held, this is constitutional bench judgment. Thereafter, this constitutional judgment came because the matter was referred to larger bench, constitutional bench, Mukesh Singh versus State. I am wrong. 31st August 2020. This judgment came, Mukesh Singh versus State, and they held merely because the informant is the investigator by itself, the investigation would not suffer the vice of unfairness or bias, and therefore, on the sole ground that informant is the investigator, the accused is not entitled to acquittal. The matter has to be decided on a case-to-case basis. A contrary decision, very important friends, a contrary decision of this court in the case of Mohanlal versus State of Punjab, 2018 judgment, and any other decision taking a contrary view that the informant can't be the investigator, and in such a case, the accused is entitled to acquittal are not a good law, and they are specifically overruled. So Constitutional Bench has overruled all these judgments, and they held we have to see case to case whether any prejudice has been caused to the accused for IO and the informant same person or not. That is to be seen, and if any bias has been, any vice has been caused to the accused, only then he is to be acquitted, otherwise convicted. Then friends, for section 43, it says recovery from public place or in transit. Then section 42 is not applicable. Then section 42 is not applicable, the provisions of section 42 is not applicable if the recovery of the narcotic drug is from public place or is from a transit, in a bus, in any public transport, taxi, in any hotel, in any other school, in any other medical institution. If it is recovery from public place on the road, then it is not applicable, and the judgments are Punjab, State of Punjab versus Baldev Singh. It is constitutional bench judgment. Then, because time is less, it has held section 42 of the Act has no application when the search is conducted in public place under section 43 of the Act, constitutional bench judgment. Then again, State of Punjab versus Baldev Singh, it is also same. Section 43 does not contain any such provision, and as such, while acting under section 43 of the Act, the empowered officer, this section 42 is not to be complied with. Then 3-bench judge S.K. Raju versus State of West Bengal, 2018 judgment, same judgment 42 is not applicable. Then I will come to section 46, 47 and 48, very important sections, friends. 46 says that it is the duty of the landholder to give information of illegal cultivation. Sometimes we come across that illegal cultivation is there in the land of a person, and he takes up the plea that I don't know who cultivated it in my land. No, he can't take this plea later on, because whenever he finds that in his land any illegal cultivation is there, he has to inform the authorities immediately. Then friends, section 47, it says every officer of the government and every panch, sarpanch and other village officer shall give immediate information of illegal cultivation. If there is common land, if it is government land, if it is forest land, the officer has to give the information, officer of the government. He may be range officer of the forest department, he may be revenue officer, if he may be a forest officer, he has to give the information immediately, and otherwise the provision is there that he can be convicted and sentenced to, I think, 1 year imprisonment. The provision is there. Then section 48 says that it is empowers every judicial magistrate of first class and judicial magistrate specially empowered to attach crop illegally cultivated. If you find any illegally cultivated crop, you can get the order from the magistrate to attach such property till it is disposed of. Then 49, friends, to stop the vehicle, you can even fire upon. You can even get this helicopter landed. The provision is to stop such animal or conveyance, or in the case of an aircraft, compel it to land and rummage and search the conveyance or part thereof, examine and search any goods on the animal or in the conveyance, and if it becomes necessary to stop the animal or conveyance, you may use all lawful means for stopping it, and where such means fail, the animal or conveyance may be fired upon. So you have the power to stop it, and even you can compel the aircraft to land if you find that any narcotic drug is being transported. Then friends, section 50 is mandatory provision. This is the only mandatory provision under the Act now. And if it is not complied with by the prosecution, by the investigating officer, by the investigation, then the accused has to be acquitted by the court. We have no other option. Although the evidence is there for conviction, but if this provision is not complied with, then every judicial officer has to acquit the accused. What is this provision, friends? it provides the most important safeguard, wherein it is prescribed that when any officer duly authorized under Section 42 is about to search any person under the provision of Section 41, Section 42 or Section 43, he shall, if such person so requires, take such person without unnecessary delay to the nearest gazetted officer of any of the departments mentioned in Section 42 or to the nearest magistrate. If such requisition is made, the officer may detain the person until he can bring him before the gazetted officer or the magistrate. The gazetted officer or the magistrate before whom such person is brought shall, if he sees no reasonable grounds for such, forthwith discharge the person, but otherwise shall direct that search be made. Moreover, no female shall be searched by anyone excepting a female. Decency of a female has to be kept. Only female can search a female. Then this provision, Section 50, Clause 4, very important. The provisions of Section 50 of the Act have been interpreted by the Honourable Supreme Court of India in State of Punjab versus Balbir Singh. The judgment came in 1994 itself, and in this it has been held that if the police officer makes a search or arrest, he should inform the empowered officer, who should thereafter proceed to in accordance with. If it is chance recovery, then it is not to be complied with. It has been held, if it is chance recovery, for example, you are conducting a checking of the vehicle, and in the vehicle, while checking the vehicle, you find that some narcotic drug is there in the vehicle. Then this Section 50, or a person is carrying in the vehicle itself, then from that stage onward, you have to inform him that you have a right to be taken to a magistrate or gazetted officer and take a search there. Do you want your search to be conducted before a magistrate or gazetted officer? If he says yes, then take. If he says no, then you can take the search, personal search. The word is personal search. In Constitutional Bench judgment, State of Punjab versus Dept Singh, that Section 50, the provisions of Section 50 are mandatory. It has been held. All other provisions are directory. They have said 52, 55, 7, they are directory and not mandatory. Then it is obligatory on the part of such officer to inform person to be searched, failure to inform the person to be searched, and if such person so requires, failure to take him to gazetted officer of magistrate would amount to non-compliance of Section 50, which is mandatory, and thus it will affect the case of prosecution and vitiate the trial, and the accused has to be acquitted. This is Baldev Singh case, State versus Punjab, Baldev Singh, 1999 case, and Supreme Court Constitutional Bench. Then friends, Section 50, again in Govt Singh versus State, it has been held that it is imperative for the investigating officer to inform the person concerned of his right. You have to inform him that he has a right to be searched before a magistrate or a gazetted officer. This is very important. You must give a statement. When you come in the court, the prosecutor has to see that the IO gives the statement in the court that I gave the option to, I informed this person that he has a right to be searched before a gazetted officer or police officer. He said, no, I don't want, then I searched him. So this statement, if comes to the court, then it is compliance of Section 50. Then Constitutional Bench, Vijay Singh Judicial versus State of Gujarat, 2011, again the same thing they have held. It is a mandatory provision and it has to be complied with. Then it is applicable only for personal search, friends. If my personal search is to be taken, then I have to inform by the investigating officer that I have a right to be searched before a gazetted officer or magistrate. But if it is from a purse, a bag, then it is not required. For example, I am bearing this coat and my search is to be taken. then I have to be given an option. I have to be informed of the right, but if suppose I have take out this coat and I keep this coat in my hand like a bag, I just hold it like a bag and search of this coat is to be taken, then it is not a personal search. Very important distinction. This is not a personal search, but when I am wearing it, it is a personal search. That's the only difference. You have to keep in mind anything which is on the body of a person, that is the personal search. It is in the hand, then it is not personal search. Yes, no specific words required. Sometimes we say there are some specified words to tell him the right. No. But the stress is on adoption of reasonable, fair and just procedure. No specific words are necessary to be used to convey the existence of right. You are only to inform him that you have a right to be searched. It is Krishna Kamar versus State of Rajasthan, AIR 2004, SC 2735. Personal search and not search of the bag, it is Kilema Thumba versus State of Maharashtra, Gurvak Singh State of Haryana. So many judgments are there. It does not extend to search of a vehicle or a container or a bag or the premises. Then Constitutional Bench in State of Punjab versus Baldev Singh 1999, it says it is not applicable for premises, vehicles, articles, etc. Only personal search. Then bag, which is known as thali in some areas. Then gunny bag, no, section 50 is not applicable. Then section 50 clause 4 says the provision of search of a lady by a female under section 50 clause 4 of the Npds Act is mandatory, and in case of non-compliance of the same, the conviction and sentence of the accused can't be sustained, and this lady was acquitted by the Supreme Court of India because the search was conducted not by a female but a male IO. So State of Punjab versus Surinder Rani or Chindi. For example, there are examples for this, that in some places the IO, he was a male and no female was with him. So what he did, he called some local lady, and that local lady was asked, okay, you take this lady inside and in privacy you search her. And then that local lady brought her back and she said this narcotic drug has been recovered from her possession. And that conviction was upheld by even the high courts. The matter did not go to the Supreme Court, but by the high court, the conviction has been upheld and she has been convicted. So, lady, the only thing is, but the IO should not be, gents IO should not be present, and in his presence the search should not be conducted. Non-compliance, the accused can't, these judges, my friends, he can't be discharged. If there is non-compliance, the accused can't be discharged. At that stage, we can't say, okay, for non-compliance of section 50, he can be discharged, because this case is from Himachal Pradesh, from Mandi district. The Sessions Judge Mandi discharged the accused by holding that section 50 has not been complied with. The Supreme Court of India, High Court upheld the judgment. Supreme Court of India said no. State of Himachal Pradesh versus Prithvi Chand, AIR 1996, Supreme Court, page 977, it says, for non-compliance of mandatory provision of section 50 of the Npds Act, the order of discharge of accused held to be improper, because what weight is to be given to the evidence collected is yet another question to be gone into during trial. So they said he can be acquitted after the full trial, not discharged. Then during my participation, friends, there is an amendment in section 50 also, clauses 4, 5 and 6. This is from my personal knowledge. What happened? I was district and sessions judge Kullu at that time, and one accused was being taken. He said, okay, I want my search to be conducted before a gazetted officer of magistrate. and while he was being taken, he threw the contraband in the river. Now how the case can be proved? Because when he was taken before a magistrate or gazetted officer, there was nothing on his body with him. So this case I narrated in the Law Commission of India that this happened. Then this clause 4, 5 and 6 have been added. It says 5 and 6, when an officer duly authorized under section 3 had reason to believe that it is not possible to take person to be searched to the nearest gazetted officer or magistrate without the possibility of the person to be searched parting with the possession of any narcotic drug, a psychotropic substance or controlled substance or article or document, he may, instead of taking such person to the nearest gazetted officer or magistrate, proceed to search the person as provided under section 100 of the Code of Criminal Procedure. And clause 6 says, but there is a safeguard. Under clause 6, it says, after a search is conducted under subsection 5, the officer shall record the reasons for such belief which necessitated such search, and within 72 hours send a copy thereof to his immediate officer superior. So it is very important safeguard, and this provision can be used by the IO if he is of the opinion that the possibility of the person to be searched parting with the possession of the narcotic drug. Then section 51 says that shall apply. This says that narcotic drugs, the provisions of Code of Criminal Procedure shall apply insofar they are not inconsistent with the provision of this Act to all warrants issued and arrests and searches made under the NDPS Act. So, section 165, that 2 local witnesses are to be taken with the investigating officer for conducting the search. Those provisions have to be complied with. You all know those. Now, friends, a very interesting case came to the Supreme Court of India. Duran Didyar versus Chief Secretary, Union Territory of Goa, AIR 1969, Supreme Court 1966. I'm exceeding my time limit, I think. So should I continue for some time or? Yes. 10 minutes. If you permit, I can take 10 minutes or, okay. Okay, thank you. So in this case, what happened? A French national was to be searched. He was at the Kolba beach. And the police party took 2 witnesses from the place adjoining to the police post. जहाँ police post थी उसके साथ के 2 witnesses ले लिए, and they went to this Kolba beach and arrested this person with narcotic drugs. 45 grams of ganja, 55 grams of opium, 51 grams of brown sugar heroin. This was recovered from him. And in the Supreme Court, this plea was taken that the witnesses were not local from the beach itself. They were from the where this police post was located, 2 kilometers away. Then IO, the statement of the IO, friends, very important is the statement of the IO. He has stated in the court, and friends, I may say, the best judge is the trial judge, trial magistrate, trial special court. Because the entire drama is conducted before us. We see the entire drama, how the witnesses are deposing, how everything is being done. Only we know. The Supreme Court and High Court, they don't have that opportunity. So we are the persons who see the drama, what happens. So 50 grams, then he has explained that actually it was a night time. It was not, there was no possibility of any person available on the beach. So I took these 2 witnesses from the adjoining the police post. And this conviction was upheld by the Supreme Court of India, and he was sentenced to 10 years imprisonment and 1 lakh rupees fine. By rejecting this, it was rejected. Punch witnesses were from this punch witnesses. Now, friends, again, next shift is from the Supreme Court judgment says, even if the independent witness is not joined, but the IO has explained it why the independent witness was not joined in the raiding party, then Supreme Court has upheld the conviction in this case. Gyan Chand versus State of Haryana, 2013 judgment, very important judgment. They said the investigating officer in his cross-examination has made it clear that in spite of his best persuasion, none of the persons present were willing to become a witness. Therefore, he could not examine any independent witness. Section 4114 of the Evidence Act 1872 gives rise to a presumption that every official act done by the police was regularly performed, and such presumption requires rebuttal. The legal maxim that all acts are presumed to have been done rightly and regularly applies. When acts are of official nature and went through the process of scrutiny by official persons, a presumption rises that the said acts have regularly been performed. In view of the above, the submissions of London Council for the accused appellants in regard to non-joining of independents are held to be without any substance, and conviction was upheld by the Supreme Court of India, although there was no independent witness in this case. So very important judgment under NDPS Act. Then another judgment, Smith Tomar versus State of Punjab. It says, though it is desirable to examine independent witnesses, however, in the absence of any such witness, if the statement of police officers are reliable and when there is no animosity established against them by the accused, conviction based on their statement can't be faulted with. On the other hand, the procedure adopted by the prosecution is acceptable and permissible, particularly in respect of offences under the NDPS Act. So, friends, the conviction rate has gone up after all these judgments. Smith, Gyan Chand, Smith, Tomar, this is under NDPS Act, they have held that even if there is no independent witness, only on the statements of official witnesses, police officers, the conviction can be there. So, this is important judgment. Again, Kulvinder Singh versus State of Punjab, 2015 judgment. When the evidence of official witnesses is trustworthy and credible, there is no reason not to rest the conviction on the basis of their evidence, and the Supreme Court held that in view of the, we don't perceive any merit in this appeal and it is dismissed. So, they said no. If it inspires confidence, they are credible, conviction can be there, so this is there. Then section 40, 52, 55 and 57, friends, they are not mandatory, they are directory. The accused has to prove that prejudice has been caused to him by non-compliance of these provisions, then acquittal can be there. Then Balbir Singh versus State of Punjab, Balbir Singh, not mandatory. Then Ashok versus State of Madhya Pradesh, again the same. Now safe custody and report of offence, same. Krishna Kamar versus State of Rajasthan. Then, friends, variation in waivement, very important. Sometimes there is variation. For example, you have taken a sample of suppose 5 grams, and in laboratory report it was 4.75 grams. There is a variation of 0.25. So the Supreme Court held this variation is possible because of weather conditions, it can dry up. Because of the other reason is that the IO has that traditional waivement scale. Scale is traditional, while in the laboratory we have computerized scale. So computerized scale is very accurate. That scale which the IOs generally have is not so accurate. So there can be variation. This is judgment of Rajesh Jagdamba versus State, then Madan Lal State of Haryana. And now last, very important, whether the whole quantity of the narcotic drug is to be seen for the purpose of commercial or small quantity, or the content of the narcotic drug is to be seen. Very important point. कि जो उसमें एक्चुअल कंटेंट है हीरोइन का, वो देखना है केमिकल रिपोर्ट में, जहाँ टोटल क्वांटिटी रिकवर्ड हैज़ टू बी सीन. फॉर एग्जांपल 740 grams of heroin was recovered. So it is commercial quantity. But CFL report said 16.93%. So it comes to 125 grams. So Nikku Khan versus Mohammedan, basing on E. Michael Raj versus intelligence officer, Supreme Court has held actual quantity is less than commercial quantity, so therefore it is intermediate quantity, not the commercial quantity. But friends, thereafter amendment was made by the Government of India on 18 November 2011. They said the entire quantity is to be seen. And after this judgment, the matter went to the higher bench. And this is, higher bench is Hira Singh versus Union of India, 3 judges bench. And they considered all these judgments, Michael Raj and all. So in this they have held, this Michael Raj is not a good law. They said it is not a good law in case of seizure or mixture of narcotic drugs or psychotropic substances with one or more neutral substances. The quantity of neutral substances is not to be excluded and to be taken into consideration along with the actual content by way of the offending drug while determining the small or commercial quantity of the narcotic drugs or psychotropic. So this Michael Raj and all other judgments are not. So the total quantity which has been recovered is to be taken as it is for the purpose of considering whether it is small quantity or it is intermediate quantity or it is commercial quantity. So friends, they have, last but not the least, it must be remembered that in the second half of 20th century, white collar crimes and especially white collar crimes and especially the drug addiction and drug trafficking have assumed alarming proportions. Drug traffickers can be termed as merchants of death and destruction. A murderer kills 1 or 2 persons at a time, but a drug trafficker spoils the lives of thousands of persons, and therefore the Parliament in its wisdom has enacted the Narcotic Drugs and Psychotropic Substances Act, thereby prescribing the death and punishment. However, when stringent punishment has been provided in the Act has also provided adequate safeguards so that the innocent persons are not sentenced to imprisonment. The more serious is the offence, the more strict proof is required. And friends, to conclude, I will only say that judges, investigating officers, prosecutors, they play a very important role in the implementation of Npds Act. And in state of Haryana, state of Karnataka versus Krishnappa, the Supreme Court of India has rightly pointed out that a socially sensitized judge is a better statutory armor in cases of crime than long clauses of penal provisions containing complex exceptions and provisos. So friends, all of us have to join hands to eradicate this problem of drug addiction from this country, from my neighborhood, because it starts from a village, it spreads to a district, then from district to state, state to nation, nation to international level it goes, because it is an infection. It spreads like an infection from one state to another state, from another state to another country. So it goes on. So friends, with these words, I request you to put any questions, any queries which are welcome, any query, any question. If I am not clear on any point, please come forward. So, yes, please.
So I'm a special judge from Joy District, Npds. So this question arises out of a bail application, and I think this is a problem. Perhaps it's pending in Supreme Court, but then we have to function, and it's regard to the non-filing of the forensic FSL report along with the charge sheet. Is it to be considered as an incomplete charge sheet, and the benefit of a default bail can be extended to the accused persons?
Yes.
So because as you know that the FSL is a big issue for the investigating officers. So they file charge sheet within the statutory period. And I personally believe that non-filing of the FSL report should not give them the benefit of a default bail, because there's nothing left for the investigating officer to investigate.
My friend from Session Judge Jawar has put a very good question, very good query, that if the charge sheet is presented in court without the report of chemical examiner, whether it is a complete challan or not complete challan. Friends, there is a provision that if the challan is not presented in court within a prescribed period, then accused will be entitled to default bail. Very important. And from this angle, this question is even more important. And I think I have read it, that the Supreme Court has held that it is an incomplete challan. Because without FSL report, we can't hold, or the investigating officer can't hold that it is a narcotic drug. So how the challan is complete? My mobile number is, you must note down my mobile number is there. So I will let you know the judgment, the citation of the judgment when I go back to Shimla. Then I will give you the citation also. The Supreme Court judgment is there. It is incomplete challan.
So the other question is that what we have seen with regard to the seizure, the entire investigation, most of the cases gets concluded at the point of seizure only. And the crux of the matter with regard to the NPDs cases is how they make the seizure in accordance with law. So since you have been part of recommending to the Law Commission with regard to the amendments, I just personally feel that why are we not using the technology instead of having an independent witnesses? Why the entire seizure process is not recorded and we comply with Section 65B? It makes things much more easier.
Very good suggestion. Very good suggestion has come that there is a technology has undergone a radical change. When we joined service, there was no computer, there was no internet, there was nothing. I know the judgment was typed by the stenographer. It will come to us. If there is a correction, the entire judgment was to be retyped by him. Today, we have the computer, we have the internet, even we can get the draft also now. That is the latest development. Because my commentary on narcotic, this Information Technology Act is also in the market. So I have done research on this subject to a great extent. So there is that's why I've said physical evidence is very important, and the IO must collect that from the spot. If narcotic drug is caught from an accused, his fingerprints should be taken immediately. And his clothes, etc. And they should be sent for DNA test. And DNA, he can be connected with the substance. And conviction, 100% conviction will be there. There is no doubt in it. So these are the things we have to go for forensic science investigation also, that side also. Physical, hair may be there, his hair may be there, his fingerprint may be there, his footprints may be there near the narcotic consignment of narcotic drugs. We can find all these things and we can connect with them through forensic science. Any other question, please? Very good suggestion. Friends, I may tell you only one small, two examples I will give. In one case, what happened, this Section 27 of the Evidence Act is a panacea for all ills for the investigating officers. Excuse me for saying this. And in one of the case, what happened, a new IPS officer was under training. and he was posted at that time in a police station. And there was a case of theft. So that recovery was made from the person concerned. And then the IO, he said, no, if we show it as it is, that we had made recovery from him, then there is chances of acquittal. Let us make this recovery under section 27. That accused gave the statement that he has kept this at his house, and then police party went, his statement was recorded, then police party accompanied him, and from his house it was recovered. And when the evidence came in the court, that IPS officer was very straightforward. He said it was recovered from the accused. And finally he was even declared hostile by the prosecutor, that he has resigned from his earlier statement, because statement was recorded as per the case of the prosecution. So this padding, if we do this padding, it is not good. Second case, I was trying a murder case. The IO who went on the spot for the first time, what he did, he recovered the drat जिससे murder हुआ, from the spot, lying with the dead body, kept with the dead body. Thereafter he was changed, new IO came, and new IO, the photographs at that time, photographs were not instant. After 4 or 5 days, the photographs will come. So photographer was taken by the first IO, photographs were also taken. And then when I was trying this case, the second IO, what he has done, he went to the spot, he started investigation afresh without seeing what was done by my predecessor, and he showed that under section 27 of the Evidence Act, that this dart had been recovered from his house, which was kept hidden by him in a box. So, no question, no question, no question. When photographer came, he's only one question, yes, you went to the spot on the very first day, yes. Dead body was lying there and this was lying there, yes. Then first IO came, okay, this was lying here, yes. Then the only argument was that the IO has said, the person who went on the spot, the photographer who first visited, they said that it was lying on the spot, but the police has recovered it from the house under section 27. So he has to be acquitted. So padding should not be there in investigating. That is my situation. There should not be. Actual, what has happened actually, that should be recorded. And I think conviction rate will increase. So any other question, please? I have taken
Good morning,
a lot
sir.
of your time. Thank you very much.
So my name is Ivan Dengdo. I am Additional SP Operations in East Khasi Hills. I have one question, sir. So is it true that a police gazetted officer who gives authorization for body search under Section 50 of the Npds Act is not supposed to take active part in the operation? That means not supposed to take active part in testing, in seizure as well, sir. Is it true, sir?
Well, the wording of Section 50 is that search is to be conducted before the officer, custody officer or the magistrate. All these proceedings are to be conducted by the person who has brought the accused person before you. He has to conduct the search. You are only to certify that in my presence this search has been conducted. So this is the only certificate which you have to be given, and then this search is valid.
Okay, sir.
This search is valid. Any other question?
One more question, sir.
Yes.
I am Bantli Nari, Rangwasinong of Nongram Hills. As one of the happens,
Yes,
as I
please.
used to happen to be one of the independent witness amongst the Rangwasinong. But okay, whatever the act of this, the NDPS Act have shown, yes, we can go follow through too much of that. But one thing, what I really want to deliberate here or to seek, if we can push for this for a fast track court. Sometimes these cases, when we go for as a witness for drug search, after 3 years we get the first hearing, for which sometimes we tend to forget what had happened in that very instance, or as such, as Rang Bachnong, one case after the other. As an example, I can tell you that I have 9 witness cases of drugs till today, and around 6 for which I've assisted. So it confused me which one is the case for which had happened. So if we can have a fast track court, where maybe within 3 months a first hearing or trial court is there, where we can give our evidence or our testimony, I think that will really help in bringing to book any offender. Thank you.
Very nice question, very nice query. And he has given very good suggestions also. Friends, in Mohanlal versus State, latest judgment, 2021 judgment of the Supreme Court of India, they have given directions to all the states to set up fast track, to set up special courts to try these offences. And the directions in their judgment are, first, that as many as special courts should be constituted by the state government in consultation with the High Court at every place in accordance with the number of cases lying pending. Second, no special court should be assigned any other work except NDPS Act cases. This is second. This is 2021 judgment. I can give you this later on. Third, if he has been given cases, other cases also in addition to NDPS Act cases, then the special judge has to take up NDPS cases first and thereafter the other cases. This is, all these directions are there in Mohanlal versus State. I can give you a citation later on because this was not in my lecture today. So these are instructions are there. And then as far as witness is concerned, friends, I must say that the witness is the most important friend of the court for the administration of justice. If the witnesses don't come in the court, then how the administration of justice to be done? He is very important person and he has to be given due respect. And once the witness has come in the court, that is also a direction in that he has to be examined in court on that day. He is right that after 3-4 years, how he can remember what happened 4 years back, and especially if he is a witness in 3-4 cases. But friend, I may tell you, you can refresh your memory. Even in court, you can say, okay, I want to refresh my memory, which is the case. And no judge will tell that don't refresh your memory. You can refresh your memory from the statement which has already been recorded by the police under section 161 of the CRPC.
Confused. Mostly I'm talking about the substance which has been seized at that point of time. After 3 years, when they ask you again, is this the substance which has been seized by the defending counsel? So at that point of time, a person tends to get confused whether this is that substance at that point of time or not.
Completely
So,
right.
yeah.
Completely right. You are completely right. So there should
Thank
be
you.
fast track cases. They should be taken from day to day. That is also direction there. That witnesses should be examined from day to day, and they should be given priority over other cases. So that is all directions are in Mohanlal versus State. So any other question, please? I exceeded actually. I'm sorry. I have exceeded. Sorry.
Can I intervene? 1 minute. Can we carry forward the questions in the next session? We'll all be here just to manage the time.
Yes.
Questions can be placed again after the next session.
So, thank you. Thank you very much.
Thank you, sir. It is apparent from the speech of Dr. J.N. Barwalia that his knowledge on the topic is vast. So now we will move on to our next session. The speaker for the next session is Shri Banraplang Jirwa. He is the Additional Superintendent of Police, East Jaintia Hills District, Clarion. May I request somebody from the Meghalaya State Judicial Academy to present a token to Shri Banraplang Jirwa.
A very good afternoon to all dignitaries who are present here today. I'm Banraplang Jirwa, Additional SP, East Jaintia Hills, Clarion, and I'll be talking about the Npds Act again, a little bit about procedural challenges that our IOs face on the field, some nuances, as well as the challenges. I think Sir here has already spoken on a lot of issues, most of the topics which I'll be covering as well. So I don't mind that Sir has taken most of the time also. And thank you so much, Sir, for that wonderful presentation. It's very enlightening, and those judgments will certainly come in handy. I'm thankful to the Meghalaya High Court as well as the Judicial Academy for giving me this opportunity to talk here. I think Director Ma'am has been very gracious enough to address me as an expert, but I think our experts are all present here. They should be the ones standing here and giving a talk on the Npds Act. I have I think, not much experience. I've been serving since 2015. I've been in charge of the ANTF in East Khasi Hills since 2019 till 22. And since 22, I've been posted as Additional SP of East Jaintia Hills, and again taking charge in charge of the ANTF in East Jaintia Hills. So in this small experience that I've had, a lot of challenges I've seen in the Npds Act, especially when it comes to seizure, the confusions that the IOs face. And I hope through this presentation today, we'll be able to address most of these challenges. I think please be patient for another 2-3 minutes. We're just waiting for the presentation to connect. So for all the IOs present here today, and again for all our representatives who have come from the various localities or from the educational institutions, your role also may come in at any point of time as a witness. So we all know that the start of any case, any NDPS case, is on three things: whether it's prior information given to the IO, or an intelligence that he receives, or whether it's chance recovery, or what we call accidental recoveries. Now, what exactly is the difference between information and intelligence? I've seen a lot of cases where the information that is reduced in writing is very vague. Okay, that is simple information, it's not really intelligence. For example, a source calls up and he says, so and so people are coming in a bus and they're carrying contraband. This is vague. It's not specific, credible source information. You need to develop on that information and then reduce it into writing. For example, a person, let's say a known trafficker by the name of so and so, traveling in a vehicle, could be a tourist vehicle, could be a bus, bearing registration number so and so, is carrying, what is the type of contraband? Is it heroin? Is it marijuana? Or is it any other contraband? So that becomes credible source information which you should then reduce into writing. Once the officer has reason to believe, either from personal knowledge or information given by any person, and then he takes it down in writing. So this is the first step for any, before you begin the investigation of any NDPS case. And as we know in the Act, if we get information or we get the intelligence, there are two sections which gives the power for the IO to act. One is section 41 and the other section 42. Sir has obviously covered all these sections in his presentation, but this is just a brief again, in very less technical terms for other members also to understand. Now section 41 is very clear that you need a warrant either from a magistrate or an authorization from a gazetted officer of the police. If he authorizes the concerned officer, then he is empowered to go and arrest, search, detain the person and conduct the seizure. But what happens if the gazetted officer is not present there or he's not able to come? In the state of Meghalaya, as we have mostly seen, 95% of our cases are generally under section 41, where authorization is given by a gazetted officer at the place. But there will be cases, especially for our IOs here, where the gazetted officer may not be present for whatever reasons. And that is when you have to take your powers from section 42, when there is no search warrant or authorization available to you. And that is when you have to understand section 42 very well, that you have to record the information and record the grounds of your belief, why you have undertaken to search and seize or arrest the person. Now, why is this recording of information so necessary? So I'll go back to one judgment, Abdul Mansoori versus State of Gujarat. So what happened here was the inspector of police at Darepur police station, he got information that an accused was trying to transport charas in an auto rickshaw. In the evening time at around 4 p.m., the accused was stopped. On checking, 4 gunny bags were found. When they took the gunny bags to the police station, 10 packets of charas were found concealed. Now this inspector did not reduce this in writing. All this information he received, but he did not reduce it in writing, and eventually he acted upon it and arrested the accused. Case was charge sheeted. At the trial court, the accused was acquitted. At the High Court, the accused was convicted. Now this went up to the Supreme Court, and the Supreme Court took the following view. As per the mandate given under 42, if the inspector or the sub-inspector had received that information, he should have taken it down in writing, and immediately within 72 hours, he should have sent for that copy of that information to his immediate superior. The court held that prosecution witness 2, which is the inspector, he cannot wriggle out of the conditions which has been stipulated in section 42. Now, the court again gave 4 reasons for this. If you don't record this information in writing, it's a deprivation of material to ascertain what was the precise information received. The value of this information is of a very high degree. Because the trial takes so many years, the inspector cannot go and say in court that I'm recollecting from my memory what was the information that I had to receive at that time. And this non-recording of information can be counted as circumstances in favor of the accused. That is why, when it comes to section 42, if a sub-inspector or inspector receives any information from any source, he has to reduce it in writing. Now, of course, they will all challenge me and they'll say, sir, but we're not like you. You are sitting in the office all the time. We are traveling day and night. We are always in the movement. Of course, then there is the other judgment, Karnail Singh versus State of Haryana. In this case, the sub-inspector who had arrested the accused, he was patrolling. While patrolling, he received a call from his source that so-and-so accused are traveling and are carrying illegal contraband with them. While he is traveling, he is not expected to be carrying piece of paper and writing down the information. So what was the judgment then? When it comes to writing down of information, receiving and sending the copy to the superior officer, it should normally precede entry, search and seizure. However, if there are special circumstances involving emergent situations, this recording of information and sending of copy to your superior may get postponed by a reasonable period, that is, after search, entry and seizure. The question is of urgency and expediency. Sir has already spoken about this judgment before, and it's again a reiteration for all the officers here. It's not, as Sir has said, Section 42 is not mandatory when it comes to an emergency situation. If you're traveling, you're not in your office, then the noting down of information can be suspended by a reasonable period, but that has to be justified in writing in your case diary. Now again, what happens in cases of chance recovery? Many a times, most of our officers who are standing in the nakas or checkposts, we ask them to check for, let's say, kidnappers or maybe for murderers. And while they're conducting checks, they find out that the person is actually carrying illegal contraband. So we have a judgment. There are many judgments in this case, but I'm just highlighting one judgment. A similar case which happened in Himachal Pradesh. The police were checking for ticketless travelers, and the accused was seen concealing something in his clothes. He was asked to disembark, and on the search, charas was found in the polythene packet tied under his belly. The case went up to the Supreme Court, where they held that since no prior information was received on being checked for recovery of narcotics, and hence Section 50, which is that notice, would not be attracted. So you can conduct the search, follow all other procedures with respect to NPDs Act, and then charge sheet the case. And in this case, and in such cases, Section 50, that is, the presence of a gazetted officer for search, will not be required. So again, for everyone here, Section 50, which Sir has already explained, especially when you are there as witnesses, it's important that you note that a GO has to be there at the site. I mean, whoever's the IO, he should be calling a gazetted officer at the site. Now, a gazetted officer from the police is DSP and above, or he can call a magistrate as well. The IO should question the accused and ask him in very clear terms, are you willing to be searched in the presence of a GO or a magistrate? And the IO also should answer in very, very clear terms, yes, I'm willing to be searched in the presence of a gazetted officer from the police or from a magistrate. If he mentions it's a magistrate, you have to call a magistrate, an executive magistrate, to be present at the site to conduct the search of the accused. If the accused does not understand your language, whether it's English or Hindi, because there in Clearyard, we have a lot of accused who are either Manipuri or Mizo. We have to call somebody who can translate as well for them to understand, because then your case will become more stronger. Because there have been judgments where the accused did not understand what did the IO say. He said that I don't understand in English or Hindi. There was no translator present, and that case has failed in court. So if the accused does not understand the language, go through the trouble to find a person who can translate the language to him and explain to him in very clear terms whether he wants to be searched in the presence of a gazetted officer or a magistrate. So in various judgments, which Sir has already highlighted, it's already held that Section 50 is mandatory and it requires strict compliance. You can all go through these judgments later on. But then again, there are certain scenarios. Like Sir has already explained about this. If you're searching the accused, nothing is found on his body, but contraband is found from his belongings, which means his bag or his vehicle, or it could be a container, it could be a purse, it could be anything. would Section 50 apply then? So we have Madan Lal versus Himachal Pradesh, Kalema Tumba, and again Pawan Kumar versus Himachal Pradesh, where again and again it has been reiterated by the Supreme Court that Section 50 will not extend to the search of the concerned vehicle or bag or container, and it's not necessary to make an offer for search in the presence of a GO or a magistrate. And again, we have another scenario. A personal search has been conducted, nothing is found, but then you find narcotics from the vehicle. But the process of conducting the personal search was faulty. That means you did not offer the person his chance to be searched in the presence of a GO or a magistrate. What would be the effect on the case then? Till 2019, the entire case would be affected. That means the accused would go scot-free. However, in 2019, Baljinder Singh versus State of Punjab, a very specific judgment has come from the Supreme Court where it has stated that the recovery from the car will sustain. That means even if your Section 50 is faulty or there has been some mistake, but if the contraband has been recovered from his belongings or from the vehicle, that search will sustain and the case will go for trial. So coming to search and seizure, again very important for all the headmen who are present here. Before the Ayog goes for the search and seizure, it's very important that he lays down before you what we call the rules stipulated under Section 100 of CRPC. The first of all, which is the IO himself has to offer for search in front of the witness. The witness should conduct the search of the IO to make sure that he has nothing on his body, which later on the accused can say that has been planted by the police in the vehicle or in the house of the accused. And this many a times these conditions are flouted by our own IOs. They were so eager to conduct the search, like sir is saying, so eager to see the contraband and just jump on the contraband that they forget the conditions of search. Like sir has said, and as far as consistency is concerned, Section 100 will be consistent with NDPS Act. So it's very important for our IOs here not to forget that when you're about to conduct the search, whether it's a vehicle, whether it's the body of the person, or whether it's the house of the person, offer yourself for search first. And this thing has to be videographed by your staff, where you have offered yourself for search by the concerned witness, properly searched, and then you begin the search of whatever the place is. Now for our IOs, the focus of the search has to be the discovery of narcotic drugs or psychotropic substance or controlled substance. Any articles or things associated with it, which means soap cases, syringes, or it could be polythene bags, any incriminating documents that could lead to the drugs, any asset or property that has been acquired in the process of financing those drugs, any other documents that could be relating to financing of drugs, or any of the other articles or things that could be pertaining to a linked crime. In this case, it could be guns, it could be vehicles, any other documents that you may find which can be related to the crime. So one thing which again sir was saying about disclosure under Section 27 of Indian Evidence Act. Now again, just to explain a little bit to our a lot of the laymen here, the law does not trust the police at all. So whatever statements that we give, it's considered inadmissible in court. However, what Section 27 says is, if we discover a fact leading to the crime, that will be admissible in court. Now, for example, if the accused is a murderer and he admits before the police that he has murdered somebody, that will not be admissible in court. But if he gives a statement saying, I know I have committed this murder and I have hidden the weapon, let's say it's a dagger, I've hidden this weapon near my house and I'll take you to the place where this dagger has been hidden. That part becomes admissible in court. Now the same thing with drugs also. What we're doing now, especially with the accused, voluntarily, we, this takes a lot of persuasion and a lot of explaining. We ask the accused, we tell them where has the drugs been hidden, It takes a lot of time. It's not a matter of 5 to 10 minutes. But eventually over an hour or something, and then voluntarily they disclose and tell the police team where this illegal contraband has been hidden, whether it's in the house or whether it's in the vehicle, in the secret chambers. Now this whole sequence is then videographed in the presence of the witnesses who are present with us on the scene. So this whole process of disclosure that is given by the accused, the whole process of leading the team, the whole process of showing exactly where in the vehicle it has been hidden or where in the house he has hidden it, all that is recorded in the what we call a document known as the Panchnama, which is then signed by the GO present, the IO present, the witnesses, as well as the accused. I mean, this is something which we had discussed together with SP sir, and we decided to go ahead with this. But again, it remains to be seen once it goes to trial how much it will stand in court. But I don't know if, I don't think sirs can be here to judge whether this is how would this would be an infraction of justice if the accused voluntarily is leading up to the whole place where the contraband has been hidden. Like Sir Khan has said, everything is properly videographed, and a 65B certificate is also enclosed when we submit the charge sheet. But again, it remains to be seen when we go to court and how our IOs are able to face the court and how the witnesses are also able to answer in court. So again, coming up to witness management, again coming up to the roles of our headmen who are present here, because most of the times it's the headmen who have to face. They are the ones who truly are witness to everything, and your statements become very, very important and relevant in court. So it's important for the IO, if not the IO, then whoever is the other officer present there, especially if it's the GO who's present, that the witnesses should be briefed very properly from the start of the NACA. That means from the time that the information is given, they are called to wherever we are setting up the checkpost, and before we give the authorization, that they are briefed about whatever information has been received, who is the person we are looking for, and what is the contraband that we are looking for. And each and every step of the process, from the time of the accused making his disclosure, the testing of the contraband, weighing of the contraband, seizure of the contraband, the whole packing process, at each and every step he needs to be briefed. I have been working with Banari also, and I was very glad that he had come up with that question, because I'll tell you, it's not an easy thing. We start, let's say discovery is made at around 11, 12 at night. The whole process goes till 5, 6 in the morning. It's not easy, I understand, for witnesses to come also. It's an harassment for them as well. But I'm very thankful that a lot of headmen have cooperated each and every time that the police have called to the police station. Whenever we call them to the police station, from there we lead them on to the place of occurrence. They've always cooperated, they've always helped us. But this is where I think the IOs, at the time when you make your statements, please show those statements to the witnesses as well. Because a lot of times I think the IOs, based on the FIR, they make a very general statement of the witness as well, and then the witness is not aware of that statement, and then when he goes to court, a different statement comes up altogether. And that's when they start contradicting. So make sure you give a statement to the witness, and the same thing goes to our public prosecutors also, briefing the witnesses again before trial. I was discussing with our public prosecutor, Bapadang. I remember he was telling me about a case where the witness, he explained to him, he told him again and again about the case, and he was telling him, do you remember the color of heroin? And he was like, yes. What was the color? Yellowish orange. 2, 3 times. Do you remember the color? Yes, yellowish orange. And finally, when he went up to stand as a witness, and the defense lawyer asks the first question, what was the color of the powder? And he said brown. And immediately Bapadang was like, what was the point of briefing you all that while? So that's why, when we are briefing, please pay attention and make sure, because a simple statement like that can easily affect the whole case and cause an acquittal for the accused. So coming up, I promised my batchmates I won't take beyond the lunchtime. So coming up again, when I joined East Jaintia Hills, with SP we had taken up this endeavor that we have to work on the backward and forward linkages. Most of the times, in most of our cases, I can understand the pressure because we don't get time to work on our cases. We forget about the supplier end and the receiver end. But this is something which we've been trying in East Jaintia Hills, and thankfully we've been able to garner some success. And we are thankful to Madam District Judge as well, who's been opposing the bails at every time. Every time they would challenge at every remand, and Madam would always make sure that she will not entertain any bail applications, because most of the times when we go and catch the suppliers, you won't get much evidence, and it's basically a lot of analysis and a lot of CDR analysis that we're able to get the evidence. I'll discuss a few cases. So 30th June 2022, we get information that 2 couriers are coming from Imphal, Jeribam, and they're carrying a consignment of 62 soap boxes and nitrazepam, around 300 nitrazepam tablets. So they are apprehended and caught. Now this is happening at around 3-4 in the morning when they are caught. They came via night super bus. So we already have another team going through their phones. We realize that the receiver and the financer are waiting for them at Maurinkening near the tea shop at the junction. So immediately, Maurinkening OC I called him and then I asked him to detain these individuals. We already have their phone numbers and everything. And thankfully I think he's not present here today, but immediately at 5 in the morning, OC Maurinkening goes there and he's able to detain them. And all 6 of them are arrested and produced in court. A few days later, another consignment, this time again coming from Jiribam. 33 boxes, both receiver and courier again present in their vehicle, private vehicle, coming all the way from Jiribam. Now in both these cases, the supplier is a lady, phone numbers are there in the phone. The supplier is a lady from Jiribam, Imphal. So we follow up on her. Eventually we get to know that this lady had been arrested by our SP sir in 2019. And then we receive source information that she is supposed to come to Shillong to give evidence in court. So a month later, the lady is then arrested on the way when she is traveling through Cleariat. This is again at 2 a.m. in the morning. Of course, on the lady, nothing is present. But our basis for arrest is obviously the calls, the nature of messages that have been exchanged between the buyer, the buyer and the receiver, and on that basis she is arrested. And thankfully they're all in judicial custody and the trial is ongoing. Again another case, couriers went to Kalany just ahead of Malidor area, this is Assam, to procure around 7 boxes. And immediately on receipt of this information, they were detained by the police at Umkyang, ahead of the Thana. Now we get to know that the person who had sent them is from Cleariat, and he is somewhere near Cleariat area. Immediately another team goes and apprehends this person. And immediately on going through his phone, we get specific chats about transaction of cash pertaining to this particular consignment. He had sent via GPay the amount to this particular supplier who was in Assam, and before he could delete, we were able to recover these chats or these screenshots from his phone, which will help us hopefully in the when the trial comes up. Now that's why it's so important that the initial 24 hours, if we're able to get to the buyer or the supplier, it will prevent them from being able to delete all that information. Again, another case, the financer is a well-known drug trafficker from Shillong, a lady. She had sent her couriers to Silchar. This is a consignment of around 9 boxes to procure from Assam. When they're coming at night, information was received and we were able to detain them. We get to know that from their conversations that the financer is a lady from Shillong. Immediately we contacted ANTF Shillong. By 5 a.m. in the morning, ANTF Shillong is already outside her house. By 7 in the morning, our team is there, and we're able to raid her place. And from her phone, we get all these transactions that she had sent to the supplier in Silchar. All transactions through money transfers that she had made from her phone. All these evidence was there, and all that we were able to collect. So that's why it's very important that we need to act immediately. It cannot be just limited to just finding the courier. If we can go ahead and get to the receiver or the financer, it builds our case much more stronger. In the month of February, we had this case again, information received about a courier delivering 1 kg of heroin, 100 soap boxes. It's around 1.5 kg. He had the phone number of the main, the financer, the lady from Shillong, but he didn't know who she was. So that trail was left like that. A month later, again, another lady will receive information that she's passing through Clarion, and she's carrying 4 to 5 boxes. So she is arrested. On her phone again, we find out that the same lady who had asked to deliver these 1 kg had asked her also to deliver these 5 boxes. And she knows this lady very well. She knows where this lady stays in Shillong. So immediately we take her to Shillong, disclosure made by her voluntarily. She identifies the place where this lady is located. She identifies the house. And accordingly, this lady is arrested from Shillong. I think District Judge ma'am will remember her very well. She caused a lot of commotion because she didn't expect to be arrested. She did not want to sign the arrest memo as well. In fact, even in court, she had created a lot of ruckus. And I think madam had to be stern to force her to be arrested. So we've had these cases. One of our biggest catches in the month of June, 2.6 kgs of heroin, 200 boxes, where information was received about 2 couriers carrying in a eco. All this was hidden in secret compartments inside this eco van, which the accused eventually showed to the police. On their information, it was known that the financer is a well-known drug trafficker from Assam. So we got the help of Assam police, and recently in the month of September, we were able to, Assam police helped us to nab him. From his phone as well, we were able to get incriminating evidence. So this is just a few examples of how we have followed up on backward and forward linkages. And like I said, the IO by himself cannot do all this. And that's where the role of the NTF team has to be developed. It has to be more than that. IOs, we know, are burdened with multiple cases. They cannot be one-man army. So what we have done in CLADAT is we have a specific team that assists the IO when it comes to testing or sampling or doing the weighing and seizure. Then another team is for going through the digital evidence, because as we all know, the mobile phone is the main source of evidence. Another team is out there helping out with the CDR analysis to find out who is the person talking with, where is he originating from. So all these things, it's eventually a teamwork which helps the IO to complete the whole charge sheet. Again, when it comes to intermediate cases, there have been many judgments, and it has made us confused as well. Because I remember there was an intermediate case where ma'am refused the bail, even though it had crossed 60 days. She had refused the bail, I think, considering that intermediate case, maybe because the punishment is up to 10 years, so the period of investigation may be extended to 90 days. But I think that judgment was rejected by the High Court, and the High Court gave bail. So I don't know, sir, if you're still in contact with the Law Commission. I think, because it's very unfair. Intermediate cases, we have, let's say, 200 grams of heroin. 250 grams of heroin becomes commercial. But the process of investigation is the same. So in commercial cases, IOs are getting up to 180 days, which can be extended till 365 days. But when it comes to intermediate cases, 60 days I don't think is really enough for them to investigate. Then again, coordination between public prosecutor and the SP office, especially during filing of charge sheet. This is very, very important. A lot of times our IOs file the charge sheet, they submit the charge sheet, but they don't take the advice from the public prosecutors. Even they have important advice to give. So even for us with Bapatang and his fellow officers, we often discuss a lot of cases before we file the charge sheet, and we often take his advice also into motion. Then again, for our IOs are trained in investigation, they are trained in proper recording of statements and everything. But when it comes to court craft, how to deal with defense lawyers, our IOs, when you make them stand in front of superior officers, they'll get the scolding for half an hour, 1 hour, and they'll not be affected. But they go to court and they stand there for 5 minutes, and you'll see them sweating. So this, I think, maybe in our training procedure or maybe in our refresher courses, the process of cross-examination needs to be inculcated in the curriculum. How to face defense lawyers, what are the different ways in which to answer, in what ways do you limit your answering, in what ways can you counter the defense. So even this also becomes part of dealing with the NTPS cases. Another factor here which one of my inspectors just highlighted today morning, sirs, especially when it comes to after charge sheet of the case, when eventually the accused get bail, it's very difficult for the IOs to trace them again. Often the IOs get transferred to other districts, and then judges will direct the IOs to go and produce the criminals in court. But when we trace back for the IOs, when they've been transferred to a different district, to go back and then trace those criminals who are especially from other states, on Assam, or it could be Tripura, or it could be Bihar, it's not easy for the IOs to trace them back. So as of now, what we are seeing is, especially in commercial cases, when the charge sheets are filed in due course of time, bail is not being given. But then again, when it comes to intermediate cases, it's difficult to file charge sheets, and a lot of times default bail is given. And again, to trace back those accused, it's very, very difficult for the IOs. So maybe we can have a detailed discussion on this, or maybe how we can involve other police states, or maybe the NBWAs can be directed to other SPs of other districts, so they can help to find the accused. So as my promise to my batchmates, I think that's done for today. Well in time for lunch. If anybody has any questions, you can please ask.
Hello, let me introduce myself. I'm the Rong Bashnong from Jiaoxiap, Lompulan. Thank you for inviting us to this wonderful workshop. The point I want to raise here is that we've seen in the media report very often when there are seizures of contraband, they give the assessment of their weight, but also the value of the contraband. My question here is, do the assessment of the value of the seizure really helps? Would it be a deterrent, or would it be an encouragement to peddlers? This is my first question. The second question is, in the previous presentation by Dr. I didn't get this name properly. He had talked about this, the complainant and the IO cannot be the same person. I would like to have some more clarity on this, about this complainant. Does it mean that the IO cannot act as a witness, Oh, what does this mean? Complainant and IO cannot be the same person, but this has been overruled by the Supreme Court in some of the cases. Thank you.
Thank you, sir. So I'll answer with respect to the first question that you have asked. Generally, when we seize any contraband, from the police point of view, it's all about the weight, because that helps us to classify whether it's small quantity or intermediate quantity or commercial quantity, and accordingly we apply the different sections for taking up the case. The value as such, that is given by Honorable DG sir and Honorable CM sir. It's based on the market value, I think, in the international market. More often than not, I don't really think this works as a deterrent, because even if the peddlers were to look at that value, even they'll be surprised at the value of that of the concerned contraband. I think they might get more encouraged to start peddling. So you have rightly said, is it a deterrent or is it something to promote? I think in a way, why our Honorable DG sir or CM sir would like to highlight this is just to show to the people the value of drugs that is transiting through our state. And this is just like what sir had said, 10% of what is actually going through. So for us, from the police point of view, from law enforcement, the value doesn't really give a difference. For us, it's all about getting as much peddlers as possible, getting as much suppliers as possible. For us, the value is just maybe for something to showcase to the media, but when it comes to actual investigation, that really does not have much value. Thank you. So the second part of the question, sir, would you like to answer that, or should I take that?
As far as the second question is concerned, the latest judgment of the Supreme Court will prevail, because it is larger bench. Larger bench is always constituted when there are two different judgments of the Supreme Court itself. And in the larger bench, they have held that the IO and the the complainant and the IO can be the same person, and accused can be convicted on his testimony. Only if the accused proves that some prejudice has been caused to him, then he can get acquittal. Prejudice means that there is something which this IO has against him. For example, there is some enmity or something. He proves something against the IO, that he has some enmity or he is with some other person who is inimical to him. Then prejudice can be shown by him. In that respect, he can be acquitted. But otherwise, he will be convicted. So he can be one same person. That judgment has been overruled. First judgment has been overruled. Thank you.
Any other doubt or query? Ba Marbo is from the police, he can answer the query himself also.
I'm not police, I'm headman.
Sir, I have one important point to raise in this point of time. That is regarding the witness management. You see, always the headman of the Rabashnong were always called whenever police catch drug peddlers or drug supplier or seize the drugs to volunteer as independent witness. But when it comes to trial of accused person, they are always facing lots of harassment in the court, as they have to wait in the court throughout the day, and later on the court used to refix the date of hearing for another date. So again, they have to reappear in the next date also. This is the reason that the headman reluctant to attend the call or to police or refuse to sign as a witness. So in this regard, I request the judiciary how to find out ways and means to solve this problem faced by the headman.
That is not for me then, sir. I think this is a question most of the witnesses question us also. Whenever we call them especially at 2, 3 o'clock in the morning, and the first thing they say is, you harass us in the morning, and the judges will harass us in the late in the afternoon. So it's not easy, I understand, because even judges themselves, they're not doing it willingly. Even when we go to court, we have to stand there, we have to wait. Sometimes the defense counsel is not ready, sometimes the accused is ill. So there are various factors and circumstances under which the date has to be refixed. Sometimes we ourselves, when we have to go and appear in court, but then some law and order issue happens, we cannot go and appear in court. So I understand this harassment has happened to a lot of people, but please don't be discouraged. Especially in Khairat, we tell the witnesses, if you get refixed, then come and have a cup of tea in the SP office, or we can have, raya or lunch or anything together. I think something which judiciary is working upon. They are also burdened with so many cases. It's not easy for them. Hopefully, as time goes along and as the situation improves, this harassment should be reduced. This timing factor should be reduced. As far as I'm seeing now in Khairat, a lot of witnesses, the day they come to court, that same day itself, they're relieved from court after taking their statements. And I'm sure the same thing is happening in other courts as well. So it's just a question of time. I hope all the headmen here, they have been doing a lot of good work. Please don't get discouraged by what happens in court for refixing, and don't consider that as undue harassment. It's not harassment. It's just the circumstances which we cannot help. Thank you.
If I may can I just add something to that?
Yes, ma'am.
Yeah, speaking from the judiciary's point of view, we understand that that the witnesses, especially the headmen, the office bearers, they are facing a problem while attending, a court summons. And we understand that they've spent a great deal of their time waiting for their case to be taken up. Now, from the academy side, we have conducted many programs on court management for the judicial officers, where we impress upon them that they should immediately check whether there are any witnesses present, and to check immediately thereon if there are any counsels present and the accused as well. If none of them are present, we immediately try to tell them that we will refix the case, understanding that they are going to waste their whole day waiting and find out only at 4 o'clock that one of the counsel is not present. So this is a strategy which we are trying to adopt, and I hope it will be considered as an important factor as part of court management. We understand the challenges and the problems faced by the witnesses, not only of the headmen, but other experts as well who come to court. In fact, even the investigating officers. Sometimes you have to wait the whole day. So this is one part which all judges are aware of, and I think they are considering this aspect of trying to take up cases quickly and to verify whether all the parties concerned are present, because if not, then they can always refix the date.
If I may add, what happened in Khairat, actually, whenever the witnesses have come, we never send them without recording their evidence. You must have seen, I used to sit in the court till 5, till 6, sometimes extended even till 7 to record the evidence. But then, at times, it used to happen because there are accused who used to come from Umkiang or from far off places. It used to take time. So we don't know whether the accused will turn up or not. So we have to make the witnesses to wait till half a day at least. But what did we do? Thereafter, if the accused will remain absent, we cannot record the evidence in their absence. We used to charge them with costs to pay for the TA of the witnesses, the traveling costs of the witnesses. And apart from that, I would like to, it's not a question actually, I would like to just share. I've had one case in Ampati and also in Cleriot, where we found that those from NGO or the BDPs, they have taken the NDPS contraband from the vehicle. They stopped the vehicle themselves. They've taken the contraband to a shed. So they have moved the contraband from the vehicle to a shed. Thereafter, they called the police. So that has casted doubts. So I would like to just suggest maybe an awareness program to them through the police or through the LASA, that they should not touch, or they just have to inform the police immediately whenever they intercept it, because they used to do checking sometimes in places. Thank you.
Very rightly said, ma'am. So like you said, the first part.
Sorry, just add one thing. Perhaps I just got an impression that the question has been directed to the judiciary. But I just want to make it, because I think people will appreciate. These witnesses are not court witnesses. These are not court witnesses. The responsibilities of the state and the prosecution. And in Thana Singh's case, it has been laid down specifically how to deal with NDPS cases. I've been doing that to the prosecutor. I've been telling to the prosecutors, give me the block dates. Give me the block dates, work out when the charge has been filed. We know how many witnesses are going to come, where the witness resides. So the planning management has to be done. And we are not going to fix up dates and dates and dates. All the dates are fixed for this case. On this date, this witness is going to come. We issue the summon. So the block dates are given and spelled out in Thana Singh's case. How do we manage that? And second is that nowadays we have the facilities of examining the witness through video conferencing. We are using it. So the headmans or these people, wherever they are residing, they can, if they find that they can adduce the evidence through video conferencing, they can do it sitting at home. All that is required is the good coordination between the prosecutor and the witness. Court has got nothing to do with that. It's not that the court, the witnesses keep on telling to the court that examine me, and the court said, no, we are not going to examine you. That's not the case. If the cases are not ready, let us not forget about the right of the accused. Trial cannot proceed causing prejudice to the accused. The court is there to see that no prejudice is caused to anybody. And they are not court witnesses.
Very rightly suggested, sir. I think maybe public prosecutors next time they can work on proper management, and then they can make sure that this option of video conferencing can also be arranged for our witnesses. And like Madam Dakhar said, like she has charged the accused for paying the TA. Then if you're getting late, then make sure the accused is also late. Then you can charge your TA from the accused. Coming back, ma'am, to the awareness, this is what we have always given out, ma'am. I think other districts are also following the same thing. Whenever we go, we mention, especially the headmen and all that, please do not detain any person even if we have suspicion that he is a drug peddler or a drug supplier. Because if you do so, this case will eventually, it'll amount to tampering of evidence, and eventually this will fail in court. A lot of cases when I was in Shillong, we had the VTP of various localities. Of course, they will be proactive. Everybody is up and against drugs. Everybody wants to play a part. But your part being is you inform the police and let the police come there, and you can play your role as an important witness during the search and seizure. If you yourself decide to be the law, you apprehend the person, you detain him, you pull out the drugs from his pockets, you've already tampered the evidence. Easily the accused will say in court that the person so-and-so, or whoever the secretary or the Rangbashnong had planted the drugs in my pocket, and very conveniently he called the police to frame me. He has a personal grudge against me. So for all the headmen here, I hope they have understood from the first session as well that the NDPS Act is very, very technical. And most of the acquittals that happen are technical acquittals because the proper procedure is not followed. And ma'am, like you rightly said, we are following that awareness wherever we go, especially for the NGOs, proactive NGOs that are there, those who are, what we call the Seng Samlas. We explain it to them. Any information that they have, convey to the police, and accordingly we will take necessary action. Thank you, ma'am. Anybody else?
So let us now proceed to lunch.
1 2. Check 1 2.
A very good afternoon to everyone. We have now come to the fourth session of the program. We have here Dr. Chayanika Sarma. She is a consultant psychiatrist and de-addiction expert, Supercare Hospital and Kripa Foundation, Shillong. So she will speak on the topics behavioral change, communication, family role in addiction, rehabilitation, reintegration, life skills, education, activities, etc. Feel free to ask queries from her during the session itself.
Thanks a lot. A very good afternoon to everyone present here. So today I'll be speaking on the medical aspect of substance abuse, of drug abuse or addiction. So first of all, let us understand what is drug. So drug is a chemical that acts on the nervous system and the brain. And after acting on the brain, it alters all the functionings of the brain. Like say a person is taking a drug, his thinking capacity will be affected, his memory will be affected, learning capacity will be affected. Then his perceptions, how he feels things, his cognition, his consciousness, all the aspects of the brain functioning get affected. And this ultimately lead to change in behavior in him. So the drugs are of different types based on the route how they are taken. So some drugs are taken by mouth like alcohol, tablets. Some are taken by sniffing like the inhalants, heroin. Some are taken via injection. Commonly it's the heroin which is injected. And some drugs are also taken sublingual, means it is put under the tongue, and from the tongue the drug is slowly entering the system. So among the sublingual drugs comes the gutka, the tobacco, etc. So next, when a person is taking drugs, we say that person is abusing drug or he is addicted to drugs. So now what is addiction? What is the substance use disorder? So according to the latest definition, it is a disease in which the drug affects the brain and the functioning of the person. It is a disease in which the affected person gets psychologically and physically dependent on a psychoactive substance. So when we say psychologically dependent and physically dependent, what we understand by that? Drug addiction has two aspects, the psychological dependence and the physical dependence. So when a person is addicted to an abusive substance, when he goes to the stage of dependency, then whenever he stays without the substance, he starts getting some physical symptoms. Like say a person is taking drugs. If he misses the dose of drug or he reduces the drug, he starts getting some symptom like he becomes restless, he gets body pain, he starts sweating, he don't sleep, his irritation becomes very high, he cannot concentrate, and fearing the physical symptoms, they continue taking the drugs. This is the physical aspect. Then come the next aspect, the psychological aspect of addiction. So what is the psychological aspect? When a person gets addicted to an abusive substance, the person starts getting craving for that. Means he always has an urge to take it. When he don't take it, the urge becomes more and more. The more he stay away from it, he have more urge, because of which at times they're compelled to take, even though they may realize they shouldn't. Then a time comes when the substance becomes more priority than anything else to them. they forget their life, their career, everything. Then the main priority is the substance. Along with that, the person persists to use that despite having its harmful consequences. Say a person is drinking alcohol regularly. He went to a doctor, the doctor said your liver is getting affected, your kidney is affected, your nerves are affected, but still he cannot resist. This is because of the psychological urge. Along with this psychological and physical dependency comes a phenomenon which is called tolerance and dependency. So what is this? When a person, as I said, takes any addictive substance, that substance acts on the brain. And then with time, the brain gets adapted to the substance. Suppose a person starts taking alcohol. Initially, he'll start with a very low dose, say around maybe less than a peg or 1 peg. And with that 1 peg, he gets a feeling of high, which he enjoys. And he wants to take the alcohol again and again. Then a time will come when taking that particular peg, he won't have any effect at all. He won't feel high, he won't feel anything. To get that same high, he will need a high dose. He'll go to 2 pegs. And like that, the amount of substance keeps on increasing with time. Along with that, the duration of high also becomes less. Suppose a person initially used to take alcohol every day, evening time, and next day he is feeling okay. A time will come then when that alcohol won't act for the whole day. Maybe after 6 hours he'll have the urge again. Maybe after 6 hours his hands will start shaking, he'll start getting restless, and then he'll feel the need to take it again. So with all the addictive substance, this phenomenon of tolerance and dependency work. The dose of the substance increase with time and the duration of high becomes less with time. That's why whatever substance a person is abusing, be it alcohol, be it drugs, with time they increase their dose, and with time the frequency of taking also becomes more. So now, if that substance is so bad, why people are taking it then? As I said, addiction is a disease. When a person starts an addictive substance, he starts by choice. But afterwards, it is not a choice anymore, it's a compulsion. He develops the physical and psychological dependency because of which he is forced to take at times. So many a times when a person starts abusing substance, it is seen the first cause is curiosity. They see other people taking, they also want to experiment what it is, especially teenagers and those in the early 20s. The curiosity drives them to the substance. They start it, and once they start it, they reach a stage when they cannot stop it anymore. And especially in the teenage group and the early 20s, peer pressure plays a very important role. That is the age when people move in groups. They prefer friends' company. And many a times, suppose 1 or 2 friends are taking in a group, then the others also get motivated. They don't want to be left out. They feel that if I don't take, my other friends will look down on me, or they won't accept me in the group. Or at times, one friend is taking, he pressurizes the others to take also. So this peer pressure plays a very significant role in the young adults. Once a person starts taking an abusive substance, he gets a feeling of high. A person takes a substance just to feel high. The high means a feeling of good, a feeling of euphoria, because the substance is acting on the brain. So once a person experiences the high, he wants to experience it more and more. He or she starts taking it frequently, and in the process they get addicted. Many a times we also see people who take it as an escape route. Having problems in life, having stress in life, they feel that if I take something, maybe if I drink, I'll forget everything. And in the process of forgetting, they get addicted to the substance. Even some drugs like steroids, they are also misused to increase the performance. And in the process of misusing, the person gets addicted to these medicines. So the symptoms of substance use can be grouped into, as I shown. First is the impaired control. Means someone starts an addictive substance, and after that the person don't have control over it. They cannot control their amount of taking. They cannot stop it on their own, because if they stop it, they start suffering. Physical symptoms start because all these addictive substances are harmful to the body. So, say whatever it is, it affects different parts of the body, and based on which part is affected, the symptoms start in the person. For example, a person is drinking alcohol. He'll get liver problem, he'll get nerve problem, he'll get blood problem, stomach problem. So different substance will affect different parts of the body and produce the physical symptoms accordingly. Along with physical problems, social problems are also very common, especially those who are taking substance like drugs. When a person goes to an abusive substance, there is change in their behavior. They, many a times to get the substance, they go to antisocial meals. They create problem at their home and also in the society. Then the drug effect of tolerance and withdrawal. Withdrawal happens when a person suddenly stops a substance of abuse. The body starts showing symptoms of suffering, which we term as withdrawal. So different substance, as I said initially, it's a disease of the brain. All substance don't act in the whole brain together. Different substance will act on different parts of the brain. Alcohol will act in one area, drugs will act in another area, ganja in another area. And based on which area the substance is acting, the symptoms are produced in the body. The symptoms are shown as per the area which is affected. So the symptoms may be mild, moderate, severe based on the amount of substance the person is taking or for how long the person is taking the substance. So the commonest substance we get is alcohol. So in alcohol, the symptoms which we see, one is the slurred or incoherent speech. When they're speaking, the speech is not fluent. Another is delayed reflex. Means they cannot act spontaneously. The reflex comes when something is done spontaneously. For example, our hand touches the fire. Without thinking, we'll withdraw the hand. A person is driving, something comes ahead of him. Without thinking, he'll just brake. So all these are reflex actions which are done without thinking, and all these are controlled by the brain. When a person is drinking, all the reflex actions get delayed. So these people are very prone for accidents. There may be loss of consciousness or blackout, suddenly becoming unconscious. Mood swings, depression, anxiety or panic attacks are very common in the alcoholics. Sleep problem. Many people who are taking alcohol, they have sleep disturbance. Either they don't fall asleep, or they sleep for a very short duration of time, or the sleep keeps on breaking, what they say, light sleeper. Headaches are also common. Along with that, in alcohol, people who are taking alcohol, the gastrointestinal problem or the stomach problems are also common. Upset stomach, diarrhea, abdominal pain, vomiting tendency, or vomiting, even vomiting blood is common in the alcoholics. Itching is also common in the people who are drinking. Erectile dysfunction. Sexual problems are common in alcoholics nowadays. Infertility is increasing. Erectile dysfunction, premature ejaculation, all these sexual problems are becoming more in people who are drinking. Sudden fall, dizziness, or poor balance may be there. Then because of the involvement of the nerve, because of the nerve damage, these people get some abnormal sensation, like they feel burning sensation, tingling sensation, or they feel as if the hands and legs are getting numb. These are because of the nerve involvement in the alcoholics. Chronic fatigue, they feel tired all the time, they have memory loss, they have difficulty concentrating, and tremors are very common. A person who is drinking regularly, slowly with time, gradually the hands start shaking. They cannot hold things, they cannot write properly. And this ultimately may progress to seizure or epileptic attacks. Redness of the face during or after periods of consumption is also very common. The next common substance in this area is drugs, opioids. So opioid includes all the substances which are of the painkiller group. Heroin, morphine, brown sugar, tablets like SP, all these fall in the category of opioids. And opioid addiction is very common in this part of India. So when a person starts abusing drugs, the addiction happens very fast. In alcohol, the addiction develops gradually. A person starts drinking, maybe after some months or a year, the person gets addicted. But in case of drugs, it may be the second dose, the third dose of intake that he gets addicted. So when a person gets addicted to opioids, this heroin, brown sugar and all, it happens that they cannot miss the dose. They miss one dose, they start suffering. And suffering in what form? They miss the dose, their craving multiplies. More they stay away from the substance, their urge to take multiplies. They get body pain. And this body pain is very unbearable for them. It's a very severe body pain. They first start with pain of the joints, then the whole body starts paining, they get headache, and at times it becomes unbearable and uncontrollable for them. Sleep disturbance is there, diarrhea is there, not only diarrhea, watering from all parts of the body. They get watering from the eyes, sweating. These are very common in the drug addicts. Tremors may be there, agitation, they become aggressive, or they may be drowsy, or they may be sedated. Speech becomes slurred. They have problem with attention and memory. They cannot remember properly. And if the eyes of these patients people are examined, the pupil inside becomes very small. This is a very significant symptom to show that they are addicted to drugs. There is lack of awareness or inattention to surrounding people and things. They have problem with coordination. They may have depression, they may be confused, runny nose or nose sores. And needle marks, who are using injections, there may be needle marks in the body in different parts, especially the hands, the stomach. Needle marks are very significant in the IV users. Experiencing withdrawal when attempting to stop taking drugs. So as I said, for drugs, even missing 1 or 2 doses, they may have withdrawal symptoms. Feeling cold turkey is very common in the drug abusers. Now, along with in the drug users, another life-threatening situation is the overdose. As I said, when a person starts taking drug, because of the phenomenon of tolerance and dependence, they keep on increasing the dose of drugs. Initially, maybe they started sniffing. A time came, then realized sniffing is not helping them. They go to injection. And with time, they keep on increasing the dose of the drugs they are injecting inside. And a time may come, they cross the limit when the drug becomes a poison for them and they go to overdose. Overdose is a life-threatening condition, and it is only time which can save a person who is taking drugs, who is getting overdose. So whenever a person comes with overdose, rather than wasting time on finding what he is taking, why he is taking, or counseling him not to take, he should be shifted to the nearest hospital as soon as possible, because it is time that can save that person. So how to detect an overdose case? First, someone suddenly becoming unconscious, unresponsive. Then his breathing will become irregular. The heartbeat will become irregular. The pulse, if checked, the pulse is irregular, beating sometimes, not beating sometimes. So the heartbeat has to be checked, the pulse has to be checked. And then the eyes. If the eyes are checked, it will say that the pupils are getting small. Along with that, he may vomit. So if a person who is taking drugs or someone is suddenly found getting unconscious, he should be first shifted to the hospital before trying to find out whether he is an addict or not, because time will save him. Another common category of addiction is the inhalants. Inhalant addiction is very common because the substance, inhalant means that is sniffed. So these inhalants are very easily available and very common nowadays. And among the inhalants are the dendrites, then these erasers, nail polish removers, floor cleaners, paint thinners, even hand sanitizers. If they are inhaled, a person starts getting a feeling of euphoria, a high. And this is becoming very common, especially in the young people, school students. Even students of class 4, 5, they start with these inhalants. So when a person is taking inhalant, how to detect that person? First, though, if someone possesses an inhalant substance without a reasonable explanation, it may be that that person is abusing it. After taking the inhalant, the person gets a brief euphoria or relaxation just for some time. then the person loses inhibition. He may talk or do things in a very inappropriate way. There may be dizziness, the person may have vomiting tendency or may vomit. And in those who abuse inhalants, they have an abnormal movement of the eye. One eye may be just involuntarily moving. This is a very significant indication that these inhalants may be there. Appearing intoxicated with slurred speech, slow movement, poor coordination, irregular heartbeat may be there, tremors, and in that person some smell of the inhalant he is using, that lingering smell. And as they inhale it through the nose, there may be rashes around the nose and mouth. Usually it is seen among students, what they do, they use the dendrites very commonly. They will empty the whole tube in a hanky, and that hanky they'll just hold in the mouth, just to get, and from that papers they get the high. Next common substance abuse is the cannabis containing substance. So cannabis is very common because it is also easily available, and in some places it is used in a ritualistic way. Cannabis, unlike heroin and alcohol, it doesn't affect the body much, but it affects the brain first. So the mental symptoms are first seen before any physical symptoms are seen. A person who is taking ganja, physically he may be perfect and healthy, but his behavior will be erratic. So a person who is taking ganja or cannabis, he always have a feeling of high. He will be always elated and euphoric. So the cannabis is taken in various forms. It is taken as smoke, which is called weed, taken with cookies, even the papers in the silims, and this called bong, not big, like structure to inhale the vapor of the cannabis. They burn it and inhale the vapor. So there are various ways of taking it. Commonest is the smoke, what they common language they say weed. So when they take ganja, it is mainly the behavior which is altered. And if they examine their BP and heart rate usually becomes more. Those who are using ganja, they usually have dry mouth and their eyes usually stay red. They have difficulty in concentration. Their reaction time, their work, their like all the activities become slow. They may have paranoid thinking. They may start having delusion, what we say. They may start hearing voices talking to them. They may see images which no one is seeing. They may talk rubbish. They may be paranoid. They may say things like someone is coming after me, someone is trying to harm me. So all the mental symptoms are seen in those who are abusing cannabis. And regarding cannabis, there is a myth that many students, they go to cannabis because they feel that if they take cannabis little at night, they can study for longer hours and the concentration increase. Actually, this is a myth. Once they start it, rather their concentration goes down and they start getting sleepiness. Then when a person is taking cannabis, there is a specific odor in their cloth, and their tips of the fingers are usually yellow in color. They have exaggerated craving for eating most of the time. A person who is abusing cannabis for a long time, they have decreased mental sharpness. Their performance at school and work becomes less. And they become confined in their own world. They isolate themselves from their society and their friends. So next group, which is the sleeping tablets. And in sleeping tablets, it is the barbiturates, benzodiazepines, and hypnotics. Many times we find that people unknowingly get addicted to sleeping tablet. Why? Because when sleeping problem is there, they just go to the pharmacy, ask for medicine, that I'm not sleeping, give me something. They take like on their own prescription, and because the dose is not calculated, the duration is not calculated, they get addicted to it. So any medicine, if it is not that all medicines are addictive, but many medicines have addictive potential if they are taken at improper dose and for improper duration. So while taking medicine also, it is because of this mistake many people get addicted to the sleeping tablets. It is not that all sleeping tablets are addictive. It is that they are taking it at inadequate doses or they are taking it inappropriately. So when a person gets addicted to sleeping tablet also, the same phenomenon of addiction works for them. with time, they increase the dose of the sleeping tablets. Maybe initially with 1 tablet they were sleeping, but because of the phenomenon of tolerance and dependence, a time will come 1 tablet won't work, they'll go for 2 tablets, 3 tablets, 4 tablets, 5 tablets, and ultimately they get addicted to it. So when a person is addicted to sleeping tablets, they have unexplained drowsiness and dizziness most of the time. Their speech may be slurred. There will be lack of coordination. They cannot walk straight or they cannot do coordinated activities. There may be irritability or mood swings. They have problem in concentrating. They have memory problems. And like in the inhalants, there is an involuntary eye movement, which is also found in those who are abusing sleeping tablet. Lack of inhibition is found. Breathing becomes slow. Sometimes BP may drop down. And because of the drowsiness, these people are very prone for accidents. They may have falls and may have severe injury following it. Meth, cocaine, these drugs are not that much common in this part, but methamphetamine is coming gradually to the northeast in the name of yaba. So what is this? So among the drugs, as I said, they work on the brain. Some make the brain hyperactive, means they stimulate it. Some make the brain hypoactive. They depress the functioning of the brain. So this cocaine, methamphetamine or yaba, these are CNS stimulant. When a person takes it, the brain becomes hyper. Brain starts working fast, and this thing, the person who takes, they start enjoying it. So when a person takes this CNS stimulant, they have a feeling of elation and excess confidence. They become very, very alert. If a doctor examines, we'll find that pupils are dilated. Their energy level becomes very high, and rather they get restless. They may become aggressive. Their speech is very fast, and you cannot make out what they're telling. It's a very rambling speech. And gradually, after some time, they start getting confused. They start getting delusions. They start getting hallucinations. So what is the delusion and hallucination? Delusion is an abnormal thought, and hallucination is an abnormal feeling. Delusion is the abnormality in thinking. A person starts thinking abnormally. He may start thinking that everyone around are his enemies. If someone looks at him, he may feel that person is conspiring against him. At times, they may become grandiose. They think they are at the top of the world. So the thinking becomes abnormal. And hallucination, abnormal smell. Why? Because the brain is functioning abnormally. Normally for us, for the brain to function, there should be a stimulus when the brain will interpret the stimulus. I see something in front of my eyes. Because that stimulus is there, my brain is working on it. But for them, because the brain is working abnormally, even without stimulus, they see, hear, they smell. This is very common in all types of addiction rather. Then, along with the hallucination, there may be irritability, they have anxiety. If a doctor examines, the heart rate changes, BP drops, blood pressure changes, vomiting tendency may be there. They may have repeated vomiting, which lead to weight loss. And as I said, the brain functions are affected. Brain functions include our logical thinking, our judgmental thinking, and our decision-taking capacity. All these things get affected when the brain is functioning abnormally. Then nasal congestion and damage to the mucous membrane. If someone is sniffing, then damage to the nose is very common. Mouth sores, if someone is smoking the drugs. And as the effect of these CNS stimulants wear off, the person goes to depression. Now, another thing which is coming up is the rave parties. And in the rave parties, the club drugs are becoming very common. So what are the club drugs now? There are different types. MDMA is there, the ZBA is there, ketamine is there, LSD is there, PCP are there. There are different types of drugs are there. But in one line, they are basically hallucination producing drugs. Means when an environment is created, say a light music is put up on, a very soothing music is put, and a person takes that substance, he starts hallucinating. He gets a pleasant feeling that as though something is happening around him, but which in reality is not there. Like say a person took LSD. And before taking the LSD, he created an ambience. He put a very soothing music in the room. He put a very, like you can say, a pleasant ambience. He decorated the room in a way that after taking it, he starts feeling something which is not actually real but relating to that room. The music he is hearing will make him feel as if he is in a different world, as if he is floating in the air, as if he is going to the clouds and from there he is seeing. Though those are not happening in reality, but the drug make him feel as though those are happening in real. And even after years, he is confused. After taking it, it did happen to me or it was my imagination. This is the hallucination producing drugs, which is very common in the rape parties. So when a person takes all these drugs, the first symptom is the hallucination. With the hallucination, he may get paranoia, he may be suspicious, he may be angry, he may be scared. His judgment become poor. He may have chills and sweating. And along with that, involuntary shaking of the body start, behavior changes start. He start getting muscle cramp, clenching of the teeth. Poor coordination is there. His inhibition becomes less. And that heightened or altered sense of sight, sound and taste, as I already told, memory problem may be there. And his consciousness becomes low. Very common in those who are taking those club drugs. So next is those hallucinogens. As I just told, in it commonly is the LSD and PCP, but they are not that common in this part of India. Usually in the metros, LSD is very common. And these LSDs, they produce a hallucination. So to get the effect of LSD, they just create an environment. They play a soothing music, they make the room comfortable, and whatever they create, they start feeling as real. So hallucinations, usually they produce the hallucination, impulsive behavior comes. Then there is greatly reduced perception of reality. They cannot demarcate whether what is real and what is not real. And there is the heightened sense of emotion. There is mood swings, suddenly happy, suddenly sad. Tremors may be there. And this may also bring permanent mental change in perception. Their way of feeling may change permanently. Heart rate becomes rapid, the BP rises. And even in later time, they have flashback of this experience as though that was something real that happened to them. A patient was there with LSD history. Even now, he went to psychosis because now also he is confused because after taking the LSD, he had a feeling that he was in the clouds, and from the clouds he was seeing his body. And now also he is confused whether it was true or it was untrue. PSP also a hallucinogen. It produces a feeling of being separated from your body and surrounding and produces the hallucination. In it there is problem with coordination, movement, aggression come, involuntary eye movement come, pain sensation goes, BP increases, heart rate increases, thinking and memory gets affected, speaking becomes problematic, the speech may be slurred, judgment becomes impaired, and they cannot tolerate loud sound anymore after using this drug. And sometimes a person may also get seizure or coma after using the PCP. So, as we said, addiction is a disease. And many a times we find that a person, he enters out of curiosity or maybe because of friends or some company. A time comes when they realize that they don't want to continue the addiction anymore because they start suffering physically, mentally, financially, but they cannot come out of it. Why? Because the moment they don't take the substance, they get the withdrawal symptoms which are unbearable for them. So as every sickness, every disease has a treatment, even addiction can be treated. And addiction is curable. So the treatment includes two phases. One is pharmacotherapy and one is psychotherapy. So pharmacotherapy is the medical treatment in which medicines are given to the person to come out of the addiction. And psychotherapy includes the counselings and the behavior therapies which are given for that person to increase his desire to come out, increase his motivation, and help him to stay sober. So the treatment includes three phases. The first phase is called detoxification. Second is called intervention, and the third is called rehabilitation. So now the first phase of treatment is detoxification. This is the medical treatment of substance. As I said, the substance is acting on the brain and making it imbalance. The substance is affecting the body, causing many defects in the body, causing harm in the body. So when a person is into something which is addictive, the person have to be first treated medically. It's very easy to tell an addict, you don't take from today. But many a times they cannot stop because they are afraid of the sufferings that will follow moment they stop the substance. There were cases when the family members did not understand the addiction. A person was fully into drugs, totally addicted, and rather than taking him for help, locked him in the room, and the boy committed suicide because he couldn't bear the pain. So the first phase of treatment is the medical treatment, which is called detoxification. So detoxification, what is done? In common language, we can say we clean the substance out of the body. We cut the effects of the substance from the body. So once detoxification is done, the person can stay without the substance. If he don't take the substance, his body won't suffer. So the goal of detoxification is to maintain the withdrawal symptoms. So in all addiction, it happens in phases. First is the stage of harmful use, when a person starts abusing a substance. After that comes the stage of dependency, when if the person don't take the substance, he starts having physical and psychological symptoms. Then comes the stage of withdrawal, a stage when a person has severe physical symptoms if he stops the substance suddenly. So in the detoxification stage, these withdrawal symptoms are managed. A person taking alcohol for long, he stops suddenly. He may get severe withdrawal in which he may become violent, he may become restless, he may get seizure episodes which have to be treated medically. And this is a medical emergency. Why? Because if the withdrawals are not managed, the person may even lose his life. So detoxification aims at removing the withdrawal symptoms. And during the detoxification, a detailed physical and evaluation is done and lab tests are done. Why? To find out which area of the body is being affected by the substance. And whatever damage is found, medicines are given to repair those also. Any associated illness that is found is treated. And after detoxification, there is restoration of overall health. Now the detoxification, which is the medical treatment, it can be done both as outpatient and as inpatient. Means sometimes it is done on a OPD basis. The patient don't have to get admitted. They just come, take the medicine, go home. But in certain conditions and based on the type of substance they are using, they also need hospitalization to be detoxed. So what are the criteria for hospitalization? First, if a person is having very severe symptoms, alcohol withdrawal, a person came, he is having seizure episodes, he is vomiting blood, he is not conscious. For detoxing, he have to be admitted. A drug addict, he is having severe body pain, he is aggressive, he is not in his sense, he is not recognizing people, he have to be admitted. Then the type of substance. Usually the mild substance, they don't need admission. Like mild substance, you can say nicotine, caffeine, they don't need, even cannabis at times. Alcohol in low dose, they don't need admission. But those who are taking very high dose, opioids, alcohol, they need admission most of the time. If a patient comes in a state of acute intoxication, means he is totally high on the substance, in a state of withdrawal or in a state of overdose, admission is must. And if because of the substance use, the person develops some physical problem or some mental problem, then also it's become necessary to admit that person. So next phase comes the phase of intervention. So during the detox phase, the person is made stable physically. So we can say the person is cleaned of the substance, the body is clean. So he is not taking the substance, he is not suffering anymore. But the habit is not gone, the mind is not clear. So many a times the person don't understand that he is addicted. So in the intervention phase, which is started along with in the late phase of detoxification, the person is counseled about his addiction. He's explained about the ill effects of the substance, and if he continue, what will be the outcome. So this is a phase when there is counseling is done to break through feelings of denial. Also to help the patient recognize the adverse consequence likely to occur if the disorder is not treated. And also to maximize the motivational level of the patient so that he comes ahead for having the next phase of treatment, which is rehabilitation. So the third phase of treatment is the rehabilitation. So when it is usually a program of 3 months in which the person gets counseling. He stay in a rehabilitation center and he get counseling. For some, they come for counseling on a OPD basis also from home. Or they come to the center, they stay the whole day, they go home. So what is the aim of the rehabilitation? When a person comes for rehabilitation, first of all, an overall assessment of the person is done. Because it's not just counseling him, you don't take. The detailed evaluation has to be done to find out first the trigger of this abuse. Why that person is taking it again and again? Is it that he has some personal issues or some tension that because of which he takes? So during the rehabilitation, first the detailed evaluation is done to find out the triggers or the causes which pushes the person to the substance abuse. And during this time, behavior therapy is also given if the person has some issues in his life which he is not able to handle. Those issues are also addressed. Some family problem is there, those are also addressed. And along with that, group counseling and interpersonal counseling, means one-to-one person counseling is given to help that person come out of the addiction and to increase his level of motivation. And also during this time, life skill training is given. In life skill training comes the skills, the life skills, like the coping skill, how to cope with problems, problem solving skills, decision taking capacity. All these skills are also taught to the person so that once he is out, he can handle his life in a better way and he don't take help of substance to find a solution to problems of his life. And during this time, to prevent relapse, means to prevent the person from going back to substance, even at times anti-craving medicines are given. So anti-craving medicines are those medicines which cut the urge for taking the substance. They are given for a specific duration, and once the person, after going out, he goes back to his normal life, he is adapted to his normal life, then slowly these medicines are removed. Now, it is, as I said, this addiction is a disease, and we say addiction is a family disease. Many a times a person is pushed into addiction because the family doesn't know how to handle him. And many a times a person comes out from addiction, but the society or the family are not able to handle them in the proper way, and they go back to either the substance or they go to depression and other mental issues. So the family have a very significant role to play in helping a person come out of addiction. So if a family is so important, the family also have to be trained to handle an addict. And the family therapies are done during the phase of rehabilitation or even after the person goes back to his home. So family therapy is a collection of therapeutic approaches where family of the psychoactive substance user plays an important role in the recovery process. So during this family therapy, the family members are taught how to deal with the person who was addicted or who is recovering. Then the family and the family resources are actively involved in the process of treatment. It is not that rehabilitation is done, he's sent back and he'll be totally fine. Once he's out of the rehabilitation, our focus is to prevent relapse, that he don't go back. So involvement of the family and involvement of the community becomes very necessary at this phase. So the family is also educated about the addiction and its varied aspect and how to deal with them. Also, when a person is addicted, the family members suffer. Because as I said, it's a family disease. It's not only the addict who is suffering, it's the family who are also suffering. Because of the addiction problem, maybe they are demanding at home, they are stealing at home, they are manipulating at home. They are creating problem in the society for which the family is embraced. Or it may be that the family member, seeing the person's behavior and addiction, they are getting depressed themselves. So all these things are also addressed during the family therapy sessions. During the family therapy, they are provided guidance, affirmation, and reassurance that family members need while dealing with addiction. This therapy helps family members understand how addiction affects them as well and how to help themselves. Families who engage in addiction treatment therapy have opportunity to explore their strength and weakness by working on them. So, during the family therapy, the interdependence of family relationship is also targeted. Many times the relations, we find that many children, they have a detached relation with the family. The parents don't have time because of their hectic schedule. And to make up for not giving time, they just give financial things to the kids. And they stay detached, they don't get the support from the family, and ultimately they take the guidance outside, or they take help of things like substance. So during this time, the interdependence of family relationship is also worked on. The family relational pattern, how is the relational pattern in the family, that is also worked during the family therapy. So, and wherever necessary, it is seen that there is something defective, that is addressed, so that the family environment becomes healthy for the substance user. So, it involves family to help user overcome obstacles, discrimination, etc., present in home or surrounding, which hinders recovery. Many times a person goes out of the rehab with a very motivated mind that I'll change. But going home, the family is not supportive. The family is not able to understand how to deal with them. They start taunting on all the things they had done before. They're not giving them time, not giving that support. And ultimately, the addicts, they may either relapse or they may go to depression. So once they are at home, how to handle them, this is very necessary to be learned. And this is taught during the family therapy. The family therapy also focuses on removing dysfunctional family patterns, which may be either present from before or arising during the addiction phase. So certain patterns in the family which makes the family environment unhealthy, or certain patterns in the family which came up because of the addiction, during the addiction phase, those are also addressed, so that once the user goes back, he gets a healthy family environment, which will motivate him to change. Also, the family therapy focuses on removing some negative behavior patterns like enabling and codependency. So now what is enabling? Many times we find that family members, because of the stigma in society, thinking that, oh, my so-and-so is taking drugs, if people come to know, what they'll say. And, or it may be that, oh, I love my son so much, I don't want people to know about his addiction. Or even at times they are afraid of the user. They start covering up. And in the process of covering up, they encourage the user to use more and more. And this pattern is addressed during the therapy sessions. Another thing is their codependency. It is also a negative behavior pattern in which the family members start adapting with the user, as if the using is part of their life. We cannot help it. He's taking. It's okay, let him take at home rather than taking outside. We give him money daily so that he don't create problem in the house. If he create problem, people will come to know. So we give little money every day so that he takes and he don't disturb us. Sometimes the addict, he plays the mind game. He starts blaming the family. That because of you had done this, I take. The family also adapts to that. Yes, somewhere we also are at fault. We cannot do anything. So they start adapting to the addiction and they start coexisting with the addiction. So all these patterns are also addressed during the family therapy. Codependency characterizes imbalanced relationship in which family members keep adapting with the user and lives as per their terms and conditions in an attempt to maintain family stability. But rather than maintaining stability, they are just damaging the family more and more. So many times it is seen that there is addiction in the family. A son is brought, a young boy is brought for rehabilitation. But he says that my dad drinks all the time, my uncle drinks all the time, so what's the problem of me drinking? So if there is addiction in the family, those are also addressed in the family therapy. Because if that addiction persists, the person who is addicted, he'll not come out. During the therapy, the behaviors which trigger substance abuse are also targeted. And the person, the family is taught the problem solving skills, coping skills, all these are taught to the family. Conflict resolution skills, how to solve problems at home, those are also taught to the family, so that the family environment becomes healthy. And the main aim of the the family therapy is to maintain the motivation level of both the family and the user, so that they continue the period of abstinence. So the family role we understand well, but does community have a role to play? A person is addicted, can say, yes, he's so-and-so son. It's their responsibility, not us. But no, the community as a whole have a big role to play to help the addicts come out of addiction and live a normal life. Because without support, a person got addicted maybe by choice or out of compulsion, but when they're coming out, they need the support, both of family and the community. Many a times it is seen that there is a person addicted in the locality, and the community members doesn't know how to handle him. He started creating problem, don't know how to handle him. So the community have a big role to play. Or even at times it is seen a person goes out from the rehab, he is motivated to start a new life, but the community is not accepting him. He goes to on the way, people just move away, no one talks to him, someone make fun of him, and he feels left out. He feels abandoned. He may go to depression, he may have mental health issues, or he think that it's better to stay an addict. I cannot be part of the society anymore. So along with the family, the community have a very important role to play. First of all, in the community, there should be awareness programs to educate people about addiction, about the various aspects of addiction, so that the people don't feel stigmatized. If suppose a young boy, he got addicted, he shouldn't feel afraid that, no, if I tell my family, if I tell people in my locality, I'll be just abandoned. Rather than that, he should feel free to come ahead and talk to people that, see, I got addicted, I need help. The family should be encouraged to come out of that stigma feeling. Then at least that addiction problem will be solved to a great extent. The awareness programs should be held, how to do, what to do, and to help the families who are facing this problem. Even if someone, say a person comes out from the rehab or has given up substance, he should be motivated and encouraged to live a normal life. He should be accepted by the society that whatever done is done, now you are part of us. Lead a normal life with us. And community participation is very, very necessary to help to remove addiction from the society. So the take-home message from that talk. First, addiction is a disease and it is curable. With help, a person who is addicted can come out of the addiction and lead a normal, productive life. Those who get addicted need helps. Understand them and support them. They can also start a new healthy life. Thank you. If any questions are there, you all are please welcome to ask.
Good afternoon, Doctor. My name is Chidi Marbo, Rangashnong of Mukra. So as per the subject today of this workshop is on narcotic drugs and psychotropic substances. Since both are drugs, but we are not explained or specified the differences between the narcotic drugs and psychotropic substances. So may I know from you, Doctor, the difference between narcotic drugs and psychotropic substances and its effects on human body? Thank you.
Both the narcotic drugs include the sleeping tablet, the opioid groups of drugs. Psychotropic drugs are the drugs which stimulate the brain. So these are substances which have a harmful effect on the brain. And as I told throughout my presentation, they have different effects based on the type of substance used. So a substance, as I said, alcohol may affect the nerves, may affect the liver, may affect the stomach. The opioid may affect different area, heart, the brain. So these substances ultimately are brain stimulating substances which have a negative impact on the brain functioning.
Yeah, Mr. Suting, the Secretary of the Bashnong Jolaido. We would like to know how many days take time for deduction that person can cure.
In the first phase, the phase of detoxification, which is the medical treatment, it usually takes 1 to 2 weeks based on the substance which is being used. For alcohol, it may be within 1 week to 7 days. For drugs, it may be, say, 10 days to 15 days. So based on the substance use and the effect of the substance, the duration is different. But it is usually, say, within 2 to 3 weeks, the person is totally detoxified.
Good afternoon, ma'am. My name is Ivan Dingdo. I am
Hello, sir.
Additional SP, Operations, East Khasi Hills. Ma'am, a few members of the society, they agree and they see that drug addiction is a disease.
Yes, sir.
But majority do not agree to that.
Yes, sir.
Ma'am, majority, what they want is stricter punishments, is an act that is more strict. And as a society, how do we move forward? Is an act that is more stricter the need of the hour, or is it acceptance or support from the community, the need of the hour?
These have actually 2 phases. First of all, once a person got addicted to the substance, he is in a helpless phase. As I said, if he don't take, he suffers. So at that point, if the society becomes strict with him, then rather than helping, he may rather go to things which is not supposed to do. If the society becomes strict with an addict, he may hide his addiction. He may, like, suppose he needs money for drugs, he'll go for antisocial means. But he got addicted, he needs the drug, he is helpless now. So the society have a role to help the addicts come out of it. So when we think of those who are already addicted, I feel it should be more of an empathetic approach from the society. But to prevent further addiction among those who are not addicted, the society have to be strict. Strict rules should be there that drugs are not available easily. Strict rules should be there that people they're scared and they don't go to addiction. But if you see who are already addicted, if the society also gets strict with them, they're already suffering. They may rather go to a more bad phase. So to prevent, as a preventive measure, yes, the law should be strict. But for those who are already suffering, an empathetic approach is necessary.
Ma'am, good afternoon, ma'am. There's one question. I'm Dr. Nari. I'm the District Nodal Officer for Mental Health in Southwest Khasi Hills. So one question I want to ask about opiate substitution therapy. What are the pros and cons of OST? Since we'll be having one OST station in Southwest Khasi Hills, because we have learned a lot of drawback for OST. Since ma'am, you can elaborate more on that.
OST is an anti-craving drug. Because as I said, for the opioid group of drugs, many a times they are not able to quit the substance because of the high level of craving. So anti-craving drugs become very necessary, especially in the opioid users, the heroin, brown sugar users. But thing is that the OST has to be monitored. All the problems are coming because it is not properly monitored. So the OSTs are misused. And many a times we find that they take OSTs just to get high. So there are instances where these addicts, they collect the OST, they dilute it, and they again fix it. There are instances like this. So while using OST, the way of dispensing the drugs should be strictly monitored. And I feel it should be done by a medical doctor so that the drug is not misused.
Hello, ma'am. I'm Mr. Wilson Darling from Meghalaya AIDS Control Society.
Hello, sir.
I was about to come to that opioid substitution therapy program. So under National AIDS Control Organization, we are implementing the harm reduction program in the state. And when we're talking of harm reduction, for the people who are still injecting drugs, we have the needle syringe exchange program. And we also have the OST or the oral substitution therapy for those people who are injecting drugs but who want to get rid of their injecting habit. It is also recognized as a treatment. It's also recognized as a one form of treatment, which I did not see in the presentation. Yes, monitoring is a part of our targeted intervention NGOs. Monitoring is a part of the TI staff, the OST staff, and we are doing our best, okay? We are doing our best from our office. In fact, we have to open more OST centers in the state, seeing the scenario of drug abuse in the state. 2.5 lakhs, the number which was given in the morning session, is a very huge number, a concern for all the stakeholders. And Additional Secretary cum DG of NACO had even instructed all the state AIDS control society that we can go for a feasibility assessment of any center where we need opioid substitution therapy. The number of the addiction center in the state is very less. We had completed one campaign in all the district prisons and rehab centers and juvenile homes and one-stop center and the other closed settings in the state. We are having very less de-addiction center. So as far as my concern is that we'll have to go for more OST program in the state. And that is the direction that has come from National AIDS Control Organization. As of now, to see whatever we can control, rather than our youth going into the illicit drugs, it's better that we promote these legal drugs. And we have seen a good example of people who have been on OST. We have seen good example of people who have been on OST who have slowly come out of the OST program. So I just want to inform everyone in the House, we need the support for all the stakeholders. Most of the police in East Gentle Hills, in West Gentle Hills, East Khasi Hills, they know about our center, they know about our TI NGOs. They are working very closely with our staff, especially when an addict is being arrested late night. Also, when an addict is being lodged in district prisons, we are there to support them in terms of OST. And I know we are still facing issue within the state. The scenario has really changed. The really has really changed compared of the addiction that has been there in the last 10 years compared to the addiction that is now. So a lot of monitoring activities has to be done from the different stakeholders. Again, what I feel when we talk about the role of the family, I think it's high time that we have preventive awareness program with the family, so that they read the signs very early. Yeah. It seems some of the family reads their signs when it's a bit too late. I used to receive call from the family members when they come to know that their son or their daughters is in addiction for about 1 year, 1.5 years, and has become very difficult for them to come out of addiction. So something which we have to do with the family is that they need to know the early signs of symptoms of a person is into addiction. That's a humble submission from my side, ma'am.
So yes, the community awareness program, school awareness programs should be rather more now to make to increase the awareness in the society. And regarding the medicines for the anti-cravings, actually I didn't cover all the, because for different substances there are different OSTs, right? So because of the lack of time, I didn't go into detail of it because it's a big list for them. And yes, the society and the family have a big role to play. And awareness programs should be more to increase the awareness so that people, they understand, they come out. And even one family is not coming out, the community help them to come out. So this is not something which can be worked alone. This is something which has to be worked together in a group. Then only addiction will be out of the society. The doctors who are working independently, the community workers working independently, police working on their own, it won't work for drugs. To eradicate this problem, it should be a combined effort from everyone. All have to work together. Then only this problem will be solved. Anyway, anything? Okay, thank you so much.
With your Lordship's permission, I will begin this. Thank you, ma'am. The speech will enhance our knowledge of the issues of drug abuse. We are honored and privileged this afternoon by the presence of their Lordships with us. Honorable Mr. Justice Sanjeev Banerjee, Chief Justice, High Court of Meghalaya. Honorable Mr. Justice H.S. Thankil, Judge, High Court of Meghalaya and Judge in charge of the Meghalaya State Judicial Academy. Honorable Mr. Justice W. Dingdo, Judge, High Court of Meghalaya. Honorable Mr. Justice Biswadeep Bhattacharjee, Additional Judge, High Court of Meghalaya. May I invite everyone to join me in giving a warm welcome to their Lordships. Before we proceed, to the session with His Lordship, Honorable Chief Justice, may I request Ma'am B. Kriyam, Registrar Judicial Service, High Court of Meghalaya, to present a token to His Lordship. On behalf of all of us here, I would like to again extend a warm welcome to His Lordship and thank him for giving his time to address this gathering in this workshop today. May I request His Lordship to guide us with his address in this session.
Join me, come. Come. Good afternoon and namaskar. This is a very important meeting, and I cannot emphasize more on how it was necessary and how we must meet continually to address the problem. About 20 months ago, when I started my visits across the state, and I would go to the districts, and some of the police officials will corroborate what I say, one of the first questions I would ask a superintendent of police in a district is how's the law and order problem, what are the main crimes, and then how about drugs. 20 months ago, several superintendents told me, drugs? What drugs? Over the last 6, 8, 10 months, that answer does not come, and people are much more serious. We must realize that whatever is caught is only the tip of the iceberg. For every capture, so to say, that you make, please remember 9/10 has escaped and only 1/10 has been caught. There are two aspects to this matter. The first aspect, several speakers, including the good doctor preceding me, had indicated, and that has to be approached with a lot of care, caution, and a degree of empathy. Because a drug user, once he's become addicted and fallen prey to the drug, really does not have any control over himself. So it's counterproductive if you get harsh and strict with the user, even though the Act provides for a punishment for use, but it's much less punishment than for those who push drugs. You must realize that one of the neighboring states where there is a lot of strife at the moment has been a prey to drugs for quite some time. Punjab, which was one of the leading states in the country, which ushered in the Green Revolution and a lot of economic growth, has seen almost 2 generations wiped away to drugs. The story goes that shoe polish was not available anywhere in Punjab, because when things got difficult, they would sniff shoe polish and get a high off that. People who are addicted, people who depend on the stimulant in the drug, would go to any lengths to acquire it or any measures to get it, because they are not in control of themselves. The second aspect of the matter is how to control. The ultimate object is how to arrest. And I'll concentrate more on the adjudication and how matters are done in court, so that some of our officials from the police department, they understand what we are looking for, because there are some statutory conditions that judges need to comply with. In adjudication and in exercising discretion that a judge has, a judge is slave to the statute and slave to the judicial precedents which interpret the statute. However much you may think that a judge has a lot of discretion, the discretion is very limited, and if there are certain parameters which are available, the discretion is available. More often than not, there is no discretion. If the offense is found to have been committed, the discretion is only in whether the sentence would be on the lower side or on the higher side or in between. There is no discretion to acquit when the offense is seen to have been committed. There is no discretion not to issue the sentence, however, the circumstances may be, because that is the mandate of the law. But before coming to that aspect, and I'll try and be brief so that we can wind up by 4 o'clock. You've had a long session. You can have half an hour of, fun time, free time. I'd want to tell you, my experience of how I came to know about all this. We had heard about, ganja and charas. We had an old help at home who hailed from North Bihar, Mithila. And every evening, he came as a cook at home and later graduated to become the manager. And every evening at 8 o'clock, he would disappear and he'd go to the terrace on the other house and put his chillum to good use and come back after a couple of hours, slightly dazed but merrier. And we used to, follow him once in a while. We've seen what he's done. And a lot of people apparently in the villages indulge in it's like, people smoking, and in several places in the West, cannabis is now become legalized because it may not have too much of a deleterious effect. Just like cigarettes are, there's a premium that you pay for having cigarettes. The taxes are very high. You can't do it in public places. You've got to be conscious of others' health, others around you. But the nicotine is something that once there's a craving, it's very difficult to get rid of. But there are no deleterious effects in the short term, though in the long term, use of tobacco and the nicotine content therein can be harmful. Is positively harmful. Why do I say can be harmful? Is positively harmful. So that was my first brush with, something like that. We knew about alcohol and, in India, the use of alcohol, except for country stuff in lower classes, was not very prevalent. We were not, the wine, even today, the wine is not a very good word in many families, because for wine they mean every kind of liquor, whereas in the West, wine is, part of your everyday kind of drink. More often than not, at dinners you don't have water, you don't serve water, you serve wine. It's a cultural matter. I went to school for my class 11 and 12 to St. Paul's, and at the boarding school, one of the first things that our rector then told us was that all of us had to be aware of drugs, what drugs could do to you, and how much you would be lured to take to drugs. And I remember that one day we used to have every day, guests for lunch. Sometimes they would speak for 10 minutes, some other times they would speak for an hour or so at lunchtime, particularly if it was not a school day or if it was a holiday. And at lunch on one of the days we had a retired brigadier from the army. If I am not mistaken, his name was Gyan Singh. And he came and told us about a boy who had parents who were very busy. We could make out from the story that one of the parents was in the army, the other parent taught at a college. They moved from place to place because of the father's shifting and transferable position. And the child did not get all the attention or even the day-to-day kind of noticing that was required. The child was very good. They started noticing him to slip, and ultimately it resulted in the child taking to drugs, becoming an addict, and then not being able to come out of it and dying. At the end of the story, he said that he was the father of that son. And the brigadier had authored a book written in first person by his son. The son never wrote it, the father actually wrote it, perceiving what the son must have gone through. And it was called I Was a Drug Addict. It's one of the most moving books that I have read. And as you can understand, the moment it says I was a drug addict, you realize that it's a posthumous book. Towards the end of the 60s and in the 70s, you had a lot of attention eastwards because of our exotic ways, because of, our philosophies, so to say. And a lot of people who were quite sick and tired of the materialism that had come upon industrial revolution, turned eastwards, and instead of imbibing the larger philosophies, some of our bad habits were imbibed, particularly the use of charas along the Himalayan range. You had celebrities coming down, you had the Beatles who came and camped over here, and people then never realized the harmful effects. But you had Woodstock in 1969, where there was open use of drugs, and then you had heavy metal and other bands where at the concerts use of drugs later grew into use of psychotropic substances. There was a question, I'll make a distinction between narcotic drugs and psychotropic substances because there's a definition in the Act. And so, it was associated, use of drugs was associated with some kind of stardom, celebrity, freedom. And indeed, if the older of you would remember, there was a movie called Hare Rama, Hare Krishna around 1971 and 72. It focused on the hippie culture. There was a hippie culture. It focused on the hippie culture, and we have seen in our younger days that these hippies would congregate around Connaught Circus. There was a huge field in the middle of Connaught Circus, which has now become a metro station, and only a pittance of the field is left. And they would be freely using their chilams and going Hare Rama, Hare Krishna, thinking that apparently Hindu religion taught that if you took the chilam and took the name of the Lord, you would achieve moksha. And there were some, fast, godmen who were also preaching that to them and making a quick money on the side. But little did you realize then, and even when the film Hare Rama, Hare Krishna was made, that it had a large, it had a different side to it. When we went to school and thereafter to college, from my batch, we lost at least 3 brilliant minds to drugs. One of them was in Jadavpur University. That man was never destined to be anything but first. And that was his career throughout his life, school and college. While everyone else was cramming to crack the IITs and the engineering colleges, he walked in, without a care, topped the examination and got his entrance. But once in Jadavpur University, he wasted himself. Thankfully, 10 years of his life went. He later returned, has been rehabilitated, but he couldn't blossom into the person that we thought he would be. There's another instance of another brilliant mind that I had some occasion to recover. At one point of time, I was a journalist and I was returning home in the middle of the night, and I was taking a cab home, or probably the company car, and suddenly there was a man who came and right in front of the car, and the driver barely managed to brake and stop hitting him. So I got down, and the driver also got down to check on how he was doing, and I realized that this was a boy who was with me in school, and he was one of the brainiest I had seen. I tried to, picking him up, talk sense to him, but he was completely out. So I left my card in his pocket, and after a week or 10 days, I found that he turned up in my office. And he was a brilliant mind because he was an expert in chess and would have made one of the better chess players I have no doubt. But because of all the drugs that he took, the many years that he lost, I was able to accommodate him in the newspaper as a chess columnist. And from there, he developed interest in business, started writing, contributing to the business part of the newspaper. And today I cannot take his name. He is one of the finance gurus of the country. But there have been, for every rehabilitation story, there have been many failures. I will concentrate on the adjudicatory part and some of the provisions of the NDPS Act 1985 and some of the recent case laws which all of us should be aware. To the doctors and the rehabilitators, knowledge of any kind is always good. This may not be immediately relevant for you, but in the context of the entire picture, if you were to follow what we were saying, that would also stand you to good stead, even though for the purpose of rehabilitation, awareness and the like, what I say may not be of much use. I'm generally not a very drab speaker, but the subject today is far too serious to make light of it. There is nothing about drugs or about the adjudication about drugs or about awareness or rehabilitation programs that can be made light of or will enable anyone to smile or cheer. But we must all be aware that awareness is the biggest trump card that we have against drugs. Psychotropic substances are salts or preparations of salts and can be various types. Narcotic drugs are generally plant-based and their derivatives. And narcotic drugs also include manufactured drugs. In fact, there are several cough syrups that when we were children we were given, including Benadryl, which contained, I believe, a bit of Fencidryl, and they have now become one of the regular forms of addiction because people just take them, down them by the bottle, throw the bottle and go, and it probably gives them a high. But children were given cough syrups as a kind of as an expectorant or to calm them down and make them sleep. But an overdose of that gives a kick. Now, it's the central government which prepares what is the list, and it's the central government which is authorized to take measures for preventing or containing abuse of all this. Previously, you would find, and our intrepid cook who later turned to be a manager at home, we used to wonder where he used to get his supply. And lo and behold, we discovered that there was a bank round the corner which had a small garden. And in a corner of the bank's garden, he had planted his cannabis and he used to get it from there regularly. So he was quite I'm reminded by reading Section 8 that it puts a prohibition on operations such as cultivation of cannabis, cocoa plants, and also prohibits its manufacturing, possession, sale and purchase. You would see that even though it talks about this, it does not talk about cultivation of poppy seeds, which is the material from which original opium is made. That's because in large parts of this country, poppy seeds are a regular staple. For the Bengali Babu, the posto, which is nothing but poppy seeds, is a very popular fare for Sunday lunch, which helps him get the late afternoon nap on Sundays. Then this begins the real part of the statute. The NDPS Act divides punishment into 3 categories based on the quantity of drug which is found in possession. There is small quantity, there is commercial quantity, and there is what is known as intermediate quantity, which is more than small, less than commercial. Here, I must say something, and I will direct it directly to the officials that I see in uniform over here. More often than not, and this is the experience of a judge who's been in office for nearly 18 years, whether deliberately or otherwise, we catch the foot soldiers, but we don't get the kingpins. I realize that you work under constraints sometimes. There are political pressures maybe, and which is why the Supreme Court has been harping on the bifurcation of the police, the maintenance of law and order, and the investigating wings of the police should be separated. And even though we are a democracy where the ultimate policy is made by the legislature and the executive, bureaucrats and police officials have to be kept immune from political interference so that they can work efficiently. You see, our examination, the IFS, IAS and IPS, is one of the most difficult in the world. It requires not only IQ, it requires a different kind of acumen to be able to crack it and to be able to get through it. I do not believe that even the lowest ranked IPS officer who comes out of the system is of average intelligence. He is much higher than average intelligence. And I don't believe that such officers don't know that when they catch someone, whether he is the foot soldier or the kingpin. But sometimes there are other considerations. Sometimes it's beyond the control of the official. And there I will exhort you that you must be true to the duty that you discharge. And sometimes discharging your duty may not lead to you being appropriately rewarded. Sometimes discharging your duty may see you being punished. But there is probably your conscience that you have to answer to. There is probably a good night's sleep that you would want to. And if you are someone who's done it by the book and not fallen prey to temptation, I suppose you'd sleep better. We will come about a situation where we will bring about a situation, may not be now, maybe in the next 5, 10, 15, 20 years, where our bureaucracy and our police will be kept immune from the whims of fire and transfer indulged in by politicians. We will, in due course, have a lot of politicians who are more educated and cleaner than today already in the Supreme Court in one of the public interest litigations. The issue is why should a politician who's been convicted be suspended only for a few years, because if an employee is convicted of a cognizable offence, then that employee suffers dismissal from service or termination. So the issue that is being looked into is, why should not a politician who's been convicted be barred from life from holding public office? These changes which I dream about won't come in a day. And why I emphasize this is because those who are at the helm of the drugs industries, and they're industries, veritable industries. In some parts of the world, they control the governments of the day. In several parts of Latin America, where you have banana republics and you have the regular coup d'etat for one military junta to replace another, all of the governance is controlled by the drug mafia. The United States has an entire wing devoted to keeping them off the shores of the United States, though the menace is now pandemic. We are aware that there are people in high offices, that there are people with high connections who are the brains behind the drugs, but we generally catch because we do not have the evidence against, or we do not have the effort of the investigation to bring out the evidence against the real kingpins. So more often than not, it's the driver of the kingpin, or it's a lackey of the kingpin, or it's a servant of the kingpin, or it is a mule, as they say, the carrier who gets caught. But the real people are never proceeded against. And you can see that I'm looking most of you in the eye when I'm saying this, because collectively you can change it. #21 is for the three categories, and punishment for violation of a drug, violation regarding pharmaceuticals and thing. The tenures are there, up to 1 year, up to 10 years and fine, and for commercial quantity 10 to 20 years. Similarly, for psychotropic substances you have similar conditions in 22. And then we come to 25, which is punishment for allowing premises, etc., to be used for the commission of an offence. This is where you come in, because if you move against premises, then a lot of people will be scared to allow their properties, because, you know, I am a landlord and I want to rent out my premises at, let's say, 10,000 rupees a month. Suddenly you'll get someone who will come and say, I'll give you 25,000. And these are mostly cases where illicit business is conducted by offering a larger amount so that you fall prey to the larger amount and look the other way. And you, the police, have your ways, you have informants, you have your channels through which information comes to you, and these are the telltale signs of illicit business, whether it is the flesh trade or whether it is drugs, and the two go hand in hand. So there's Section 27, as I told you, was punishment for consumption of any narcotic drug or psychotropic substance, but it is very liberal, because the purpose of the act, yes, to arrest the consumption altogether, but that does not mean that you treat the victims The drug addict is a victim of the system in the same manner as you treat the perpetrators. Unfortunately, most of the mules that you'd catch, as you would know, are drug addicts themselves. Some, to get drugs, they become mules. Some others, in course of being mules, they become drug addicts. For a repeat offender, there's even the death penalty. Indeed, in several countries, including some Islamic countries, the penalty is straightaway death. And therefore that is a great deterrent. But of course, in our country, it's for repeat offense. And as it also happens that we are slowly moving away from the death penalty kind of system, because in our penology, we are becoming more of reformative rather than retributive. And so our jails are now called correctional homes, and we are trying to reform rather than punish. 31A continues. Now this is one of the most important provisions, particularly for judicial officers. As you know, under the Evidence Act, Section 4 provides for three things. One is the court or the judge may presume. Second is the court or the judge shall presume, Section 3 rather. And the third is shall presume and may presume. Now, what is the difference between shall presume and may presume? When the mandate of the statute is you shall presume, it means that you will take it to be a fact unless it is disproved. And when the mandate of a statute is you may presume, it means that you have the discretion to either take it to be a fact or require it to be proved. And in evidence, there are three things. A fact may be proved, a fact may be disproved, or a fact may neither be proved nor be disproved. If a fact is proved, that's the end of the matter. If a fact is disproved, then it means it did not occur. But if a fact is neither proved nor disproved, then you're in this state where you do not know how much to accept, but surrounding circumstances tell you how much to rely on that. Section 35 of the NDPS Act does not refer to the Evidence Act. So please do not, judicial officers, mix up shall presume, the expression shall presume used in Section 35, and again I'll come back to it in Section 54, to imply that it will have the same meaning as in the Evidence Act. Literally, no. But both Section 35 and Section 54 indicate what shall presume means. Effectively, it means the same thing as the Evidence Act, but it is inbuilt in the provision itself, and you do not have to go to the Evidence Act to look for its meaning. There is an explanation about culpable mental state. Culpable mental state is the guilty mind, really. That the person had knowledge that what he was doing was wrong, that the person had a motive, and if these two are there, then it demonstrates a culpable mental state. And as to the expression shall presume, which is used in the third line of the provision, please come to subsection 2, which says, for the purpose of this section, a fact is said to be proved only when the court believes it to exist beyond reasonable doubt, and not merely when its existence is established by a preponderance of probability. Judicial officers would know that the test of proof in civil matters is preponderance of probabilities, whereas in criminal matters it is beyond reasonable doubt. However, in criminal law, when there is an exception, then the exception has to be proved on the test of preponderance of probability. Whereas, because this is a strict act, the exception in this case has also to be proved beyond reasonable doubt. That's what subsection 2 says, and which is what this act is. It's a rather draconian and serious act. The offences are triable by special courts. Now I come to one of the everyday provisions which all judicial officers in special courts or taking up bail matters come across. The general rule is in NDPS matters there is no bail. However, there is a distinction between the rule of no bail in NDPS matters and the similar provision in the Scheduled Castes and Scheduled Tribes Atrocities Act. In Scheduled Caste and Scheduled Tribes Atrocities Act, it is forbidden to grant or even to seek. In NDPS, it is not forbidden, but to grant the public prosecutor or the person appearing on behalf of the prosecution may agree to it because there is no material, or if the public prosecutor or the agency opposes the prayer for bail, the judge, on the basis of prima facie assessment of the material, should come to a conclusion that a conviction will not be granted in respect of the applicant, and that it's a twin condition, and that letting him free will not have an adverse effect in society. They are very high tests, but both these conditions have to be met before bail can be granted in a matter. And perforce, an opportunity has to be given to. You see, while we are on this, the NDPS Act is quite a draconian statute. Indeed, once you are caught and it is alleged that you possessed, the burden is on the accused to prove his innocence, which goes against the grain of natural justice and criminal jurisprudence, which says that a person is innocent till proven guilty. We now have certain statutes like the POCSO Act, like the NDPS Act, where upon being accused, there is a presumption that you committed the offense. But the burden is on the accused to disprove it. When considering whether bail is to be granted or not under Section 37 of the NDPS Act, oftentimes as judicial officers we come across X was caught, he possessed, and in course of his interrogation, he incriminated Y or he disclosed the name of Z. So Y has been arrested, Z has been arrested. Now please listen to what I have to say very carefully. Like Section 498A of the Penal Code, which has on many occasions been abused against husbands or husbands' families, and sometimes, believe me, with connivance of the husband against the husband families. The NDPS Act is sometimes used, with due respect, by the police at politicians' behest to keep some elements away from public glare or away from roaming the streets. Sometimes what is used is pre-captured drugs are planted for such purpose. Sometimes for no rhyme or reason they are arrested and something is shown, someone said. Now it's very dangerous, particularly in a democracy governed by rule of law, where Article 21 of the Constitution has been read up so much, despite it being coined in negative terms. There is nothing stopping, theoretically, a person in possession being questioned and such person taking even my name. Then the Chief Justice is involved. Would the police come and arrest the Chief Justice and also say that he's been incriminated by the one who was caught with possession? So when the only material that you see is the allegation of a co-accused and the state does not seek any more time, or you've granted the state previous time to bring material against the applicant, but the state can't produce any material other than the mere allegation of the co-accused. That is one of the situations where the second limb of Section 37 would come into play, and you may, provided you are of the opinion that the other condition will also be satisfied, that the discharge from custody of the applicant would not be prejudicial to society or result in greater sale or use or supply of drugs, you can grant bail. Why I say this is because somehow in our judicial system, because trials take a long time, and I must repeat what I said at Nehu yesterday, that however much, the police blame, however much everyone blames both the judiciary and the police for trials taking long or trials not resulting in the appropriate results, you must realize that considering the population of the country, the police population ratio is the worst, and the second worst is the judge population ratio. There should be many more police personnel than the numbers that we have. In fact, in Meghalaya, it's worse than the national average. There is a particular district which has been carved out, may have been carved out for political purposes. There is one police station in that district. The second police station has not yet come up, and a district has been carved out. Before you carve out a district, you must ensure that you have adequate personnel who can be kept apart for investigation, personnel who will manage law and order. There are many parts of the country where you have one police station in maybe 100 or 150 square kilometers. So in one corner, there is a riot. In another corner, there is a murder. And in the third corner, there is some VIP movement. God help the rioters, God help the murderers, is the VIP duty which receives attention. That's the feudal culture. And if you, in your position, do not protest this feudal culture, yes, it is necessary to protect VIPs. It's necessary to give them some respect. But, having 22 people surrounding you and gun-toting people around you may boost your ego. But if it is not necessary, it's a colossal national waste. And you people should be protesting that, and you people should be downgrading the security of a whole lot of other people. Today it's become a status symbol. I have 3 cars in front or behind, so I am a bigger hero than someone who has 2 piddly officers in front or behind. These things come off awareness. These things come off, people in your position and influence who can rise up and stand up against them. Today we have, and I'm talking about 2010, 12 to 13 judges per 10 million people in the country. If you go by a 1982 Supreme Court judgment, today we should have had nearly 180,000 judicial officers in the country. Against that we have, beginning the magistrate who was appointed yesterday, right up to the Chief Justice of India, sanctioned post of about 21,500, less than 22,000. And actually we have about 19,000 or so in the district judiciary. We have slightly short of 1,000 High Court judges, and against a sanction strength of 34, we have 32 in the Supreme Court. For a country of the kind of population that we have, for a country of the size that we boast of, we do not have adequate personnel or infrastructure for either the judiciary or for the police. And it is an excuse that has worn out now that we are a poor country and we cannot afford more resources. We are no longer the poor country that we were, and it's high time we augment our resources to ensure the rule of law and to ensure the maintenance of law and order. And without meaning disrespect, I must say that there is a class which does not want poverty to be removed. There is a class which does not want the rule of law to have primacy. And there is a class which does not want law and order to be the order of the day. But with awareness, with how you exercise your vote at the hustings, with how you stand up and have yourself heard, we probably can get into a better situation. I'm sorry I digressed, but those are hard realities. Today, if you're a policeman, it's almost kind of normal to be expected to be understood to be corrupt. That's the image. And any police officer or anyone in the police has to disprove whether that he's corrupt. The image is slightly better in the judiciary, though I must say in Meghalaya, except for one senior officer against we have a lot of material, by and large, things are much better than elsewhere. Before coming to Meghalaya, I was in Madras as the Chief Justice. And in course of my 11 months over there, we dismissed 33 judicial officers on the grounds of proven corruption. So, corruption is there everywhere. There is corruption in the society. There is no point of denying it. And the only thing to do about is to deal it with a heavy hand. And we will be getting very soon to the officer against. We have material now, because sometimes it's a whispering campaign, sometimes you accidentally get some material that can be made the basis for proceeding against, At the end of the day, when we dismiss anyone or take action against anyone, the test is, again, beyond reasonable doubt. And just because the judge is strict and 10 lawyers who lose clients or who lose matters start a campaign does not mean that the judge is corrupt. But if it comes from different stations where he or she has been posted and from persons who are otherwise reliable, who do not speak ill of every judicial officer, then you've got to sit up and take notice. And we've taken notice and we have some material, hopefully, to proceed. Anyway, that is another issue. I don't want to detain you with the other, except about Section 50 and Sections 42 and 43. Because this is an act with very painful consequences for an accused, it calls for a strict interpretation. And in such a scenario, there is an old principle which comes down which says that when a law requires a certain thing to be done in a certain way, it shall be done in that particular way and in no other. When a person is found to be in possession, that person then has to disprove that he was in possession, or disprove that he was aware that he was in possession, or disprove that he was aware as to the nature of goods that he was in possession of. So therefore, to establish possession, there are some strict rules. There are some kind of gazetted officers who are empowered by the Act and pursuant to notifications issued under the Act. But it is the duty of the gazetted officer to inform a person if he is approaching the person with prior information that such person could be in possession of drugs or narcotic substance, then it is for that gazetted officer to make the person known that he can be checked in the presence of a magistrate or another gazetted officer. And if that is not done, then it vitiates the entire process. May not vitiate the possession, but it would vitiate the culpability and the sentencing of the person who's been found in possession. Of course, there's a distinction which has to be made. Sometimes you go to raid, though raid is no longer a good word even in income tax jargon now. Sometimes you try to apprehend on the basis of information, reliable information. Now when you get every sort of information, if someone tells you that it's raining golden geese in Police Bazaar, you will not be enthused to run and go after it. But if you get what you perceive to be credible information, it's only then that you will pursue. So what the Act refers to is information leading to reason to believe. So if you have reason to believe, based on some information, that an offense is being perpetrated or a person is in possession, then you go. And when you do that, there are certain checks and balances that the statute requires you to follow. And if those checks and balances are not followed, the consequence is that the accused gets out of the rigors, because this is a harsh statute which provides for strict punishment and presumption as to the culpability of the accused, if you do not perform the things required by statute as the statute mandates, then that work is not done. However, apart from recoveries which are made upon obtaining information and having reason to believe, there are other situations where you may make a chance recovery. The rigors which are attached to recovery upon reason to believe are not attached to chance recoveries. Say for instance, you have set up barricade because there's a high security dignitary who's visiting the area. And basically why you've set up barricades or Naka party, as they say in North India, is to see that no extremist comes in. And in course of that, you discover drugs or psychotropic substances. That's a chance recovery. You have not attempted to search or ascertain because you had information or reason to believe. But in course of some other activity, you've made a chance recovery. So those do not require the rigors to be followed. But we must know, as the police, you must adhere to the statutory requirements, otherwise, ultimately, the conviction of the sentence is not possible. When I'd spoken about section 35, I'd referred to section 54. It's the same. It may be presumed he has committed, and it's the same kind of principle that follows, that if a person is found in possession, then that person can get away by either establishing that he was not aware that he was in possession, B, that he was not aware that the goods that he carried were prohibited goods, or any other ground that may establish his innocence. Oftentimes you have drugs caught in a vehicle and the driver, trucks and other things, and the driver of the vehicle would say, no, I had no idea. There was someone else. I just drive. I don't know what is there. In those cases, there are a body of judgments which indicate how you should approach the matter. I will not go elaborately through this because I hope our judicial officers are aware of that. And some of these principles, I hope that judicial officers and police at the district level sometimes interact and share your experiences so that, both of you can build the knowledge base of the other. Both judicial officers and the police, we are the state. However, the judicial officers are the checks to ensure that citizens are not unnecessarily proceeded against, or only those who are culpable are ultimately brought to book. We are part of the same process. You lead them to us, but we are the filter through which they ultimately pass. We are the screen which stops those who should not pass and let the others who are found to be guilty to go through to where they deserve to be. There is an amendment which gives immunity from prosecution to addicts volunteering for treatment. As I showed you that there was a provision for use when it's an addict who volunteers for treatment, then there are certain immunities which are granted. There are some cases that I will ultimately make my PowerPoint presentation available to whoever may be interested. I do not want to continue any further. There are several cases which instruct on how to interpret some provisions. Some of the leading cases that I have brought pertain to in what circumstances bail may be granted. The other is that there is a Constitution Bench judgment now which says that when a confession is made under Section 67 to an official empowered, were a police officer, and therefore that confession alone cannot be used for conviction. There was a dichotomy of views, and even previous Supreme Court judgments which said that no, this is not confession to police. And that check is necessary because, you know, I'm not criticizing the police over here. At times, there are extrajudicial methods which are used for extracting a confession. And so if you are beating up a man and he can't bear the beating anymore, then he may find it easier to confess because that will stop the beating even if he has not committed the crime. Therefore, in India, we don't look at the person running away from a scene of crime to be convincing enough to point to his guilt. We do not see in India a person not surrendering to the police to be conclusive of his guilt, because the image of the police is such that, and we need a facelift of that image, is such that people don't voluntarily or quite agreeably come to the police because they are aware of the consequences that follow. Indeed, the same images of the courts, because witnesses, particularly dispassionate witnesses, do not tend to come forward, do not tend to come to trials because, let us say, a witness is a daily wage earner. How many days of wages will he miss to come as a witness? Because there is no certainty that if the trial is fixed today, the trial will be taken up, or that he will get a chance. And the pittance that is given as witness allowance is not enough to compensate him for the loss of his daily bread. These are matters of policy which are beyond the judiciary and are beyond the police and up to the policy makers, but these are actually the harsh realities. The third aspect on which I had brought some case law was, one is on bail, the other is on confession under Section 67, and the third is on the distinction between chance recovery and recovery pursuant to information upon having reason to believe. The final aspect is, there was a previous decision, famous decision in E. Michael Raj, which said that if a prohibited substance were to be mixed with a neutral substance, then the weight or volume of the neutral substance would not be taken into reckoning for the purpose of ascertaining whether it is small quantity, intermediate quantity, or commercial quantity. That previous Supreme Court judgment has been overruled now, and in the latest judgment they say that even if it is mixed with a neutral substance and the prohibitive substance is only a fraction of the neutral substance, the entirety of the end product must be taken into account for the purpose of determining whether it is small quantity, intermediate quantity, or commercial quantity. So the Supreme Court, in giving that interpretation, has made the statute harsher, and we must be aware that all this is because of the much greater use of drugs. There were times when we would think that drugs don't happen at home, it happens somewhere else. But now each one of us is affected by someone we know, someone who is dear to us, or someone we had thought very highly of, who's fallen prey. For the victim, it is a disease, but for us who are, so to say, the protectors of society, it is our duty to make a lesson out of anyone who is caught so that it acts as a real deterrent. And it will not do to merely catch and prosecute mules. Unless some big heads go rolling, the menace will not be arrested. Thank you for giving me a patient hearing. As I said that, when it comes to this matter, it is only seriousness and nothing else. I hope today's discussions, deliberations have aroused enough or motivated you enough to take adequate steps. We are in positions of responsibility, both you on the police side and we on the judicial side. We are in positions of responsibility where the society counts on us, and that obligation we must discharge honestly and to the best of our ability. Thank you. God bless you all. Jai Hind. Kublai Mithila. Driver's best.
Thank you, Your Lordship.
Driver's best.
Thank you all for your presence and unwavering commitment. Have a meaningful day ahead. Let us all proceed for tea.
Yes, it was about an hour.